5. This case, writ appeal is pending, madam. So, writ appeal is fixed on 16 tomorrow for hearing, madam. Let the matter be listed after 4 weeks.
For the education,
My lord, I am.
He knows.
45 of the request of MSK Devi, counsel for petitioner, request and defects to be listed after 4 weeks, and it is submitted to the bar that the issues raised in the present petition are also part of a writ appeal which is presently pending disposal before division bench of this court. List accordingly. Yes.
May I please? I beg to mention for listing of an admission matter, my lord. A long pending case, my lord. Any date, my lord, if possible, in this month, my lord.
Let it be in August.
First week, my lord.
First week. 3rd of August.
Highly obliged.
May I please, your lordship? I beg to mention item number 9, your lordship, for withdrawal, your lordship.
Item 9
9, your lordship.
is submitted by the council.
Yes,
But the writ petitioner does not wish to press the petition any further and seeks to withdraw. Same accordingly. The petition stands dismissed on withdrawal. Interim orders passed. If any, stands vacated pending either. Also.
Liberty may be given, to file a petition.
Why you want to withdraw?
There are lots of typographical errors here.
These council submits that there are a lot of errors which is crept in and has prayed for liberty. Accordingly, liberty granted.
May I please? I beg to mention item number 29 of today's list. Well, here I need some time. I have received the instruction but partial, not complete. That is why I need 3 weeks time.
Rules for the petitioner.
I am waiting for a bit.
Any objections?
May I pay for a date, my lord?
29, the request made by Mr. Bora for the council for the elementary education.
My lord.
Stands deferred. Be listed after 3 weeks. Mr. and Decca council for the petitioner. It is does not object to be prayer made. List on 7-8.
My lord. Obliged. I beg to for listing of application on Monday, lord.
Why?
The transfer matter, lordship. The matter was last listed on 26, but on date the lordship's bench was not available.
Transfer.
Lordships.
Motion matter.
Lordships.
I am paying for listing on motion matter on Friday.
Friday.
Mr. Lordship, I could mention for listing.
Admission August. 5th of August.
Lordship, I am mentioning item number 30. Kindly pass over the matter for any other.
Item 30.
13.
30.
13.
Item 13 on the request of the council for petitioner stands passed over to the.
I am praying for an adjournment in item number 11.
11. So the respondent, petitioner. Any objection? Item 11 on the request of the council for petitioner stands deferred. List
Can it be next week in a day?
list next week. Permitted time to file additional affidavit. The office note reflects no additional affidavit has been filed as on date. None also represents the writ petitioner. Respondents 1, 3 and 1, 2, 3 and 6 are represented by the standing council. Second, common advocate. List accordingly after 1 week. Yes, Mr. Bhuya.
The operative part is at page number 34. So there is a direction for current salary as well as arrear. Current has also not been paid yet.
But the party being agreed by the alleging willful disobedience, non-compliance with the directions contained in the order.
Dated 15/9/25.
15/9.
25. Page 12.
15/9/25 passed in WPC number 5996 of 2022. The petitioner has filed this present petition. Notice returnable 4 weeks. Steps on respondent by speed post within 1 week from.
Obliged.
Yes, Mr.
Was appointed as an assistant bishop at page 13. Page 13. He was appointed as an assistant bishop. Then the service was provincialized. But the order of provincialization is page 17. Serial number 7. Yeah, nursery.
You're claiming advance increment
Yes,
for having obtained B.Ed.
yeah, earlier, prior to my appointment, I obtained the B.Ed degree. So,
On-
my lord,
The last occasion you were required to produce some material.
yes, I have brought it. Judgment of the Honorable Court. Because order of provincialization, order of increment was cancelled by the government, and that order was also set aside by the High Court. Then the government went on appeal, but the appeal also Honorable High Court held, the example held that those who obtained B.Ed degree prior to 2012, they will get the increment. I have brought that. I am pressing the judgment of the division bench.
Yes.
Tara 8. Why that she had joined before 3712 and obtained the B.Ed degree. That is prior to 2012. The teacher must obtain the B.Ed degree. Then they are entitled for one advance.
You joined in service
I joined in service my lord long back on 2007.
and you were a B.Ed at that point.
B.Ed my lord. Joining letter I have done my lord at page. The B.Ed degree obtained at my lord page. Page 12. 12. He has obtained the B.Ed, passed the B.Ed final examination September 2008. Then what's it? Then his service he was appointed, and then what's it? Service was provincialized. Prior to that, our service was also approved long back by the government. Then when she was provincialized, service was provincialized, my lord, she should have been given an advance agreement. But that was not done. That is why the petitioner is before lordship. Petition that issued by the government on 22/10/14, the cancelling the increment order to the teachers has been set aside. And this is the order at page 32 of the Badal Landed single glass. And that is not interfered by the Honorable Appellate Court.
Yes, what do you say, respondents?
Lordship, in case of notice to issue, Lordship, I'll complete my instruction in that case. Lordship. I'll be paying for the BDC. We take the instruction.
What is this?
And that order of the learned single judge.
Against which the appeal was filed.
That order is not interfered by the honorable division bench.
All right, we'll issue notice then.
Well,
Heard Mr. Ashish. Senior counsel, assisted by Mr. Sundro. And Mr.
NR Sharma Lordship for respondent number 3, 4, and 5.
Here for the PTC, respondents 3, 4, and 5. Who's for 1 and 2?
I will give it. Secretary.
That's for 1 and 2. Since the respondents have entered appearances, notices away, extra copy will be furnished. In a period of 1 week from today. Respondents will apprise the court as to why the petitioner's claim for grant of increment,
one advance.
one advance
Only
increment
one.
for one advance increment for the B.Ed degree which we required prior to her date of appointment was not granted. List again after the return.
Look,
That काम को judgment get a grade one. Total fee revenue. Date of the judgment, party name, order. It's number.
Made development. Last 2 occasions, my lord honorable court directed to the standing council, my lord, to obtain instruction, my lord. My lord, there is a specific direction, my lord. Please may kindly see 134 page, number 20, 134 page, annexure 29. There is a judgment, my lord, and on operative portion, page 142, my lord.
Stating what?
Yes, my lord. Para 13. For the reason stated above, order of the commissioner and secretary so and so is set aside. The matter is again remanded to the principal secretary pass a fresh order, strictly taking note of the conclusive already arrived by this court in judgment dated so and so passing those which has already been referred here in every clear and so within a period of 1 month from the date of receipt. And thereafter, my lord, they filed an appeal before the division bench. That was also dismissed, my lord. And thereafter, they pass an order, my lord, page 151. 151, my lord. The second paragraph finding, my lord. In view of the above, department has fully examined the matter, taking note of the conclusion already arrived by the court. Its judgment dated so and so, WBC number so and so in WBC so has concluded that present petitioner deputy does is also entitled to claim parity with the relief that were the granted to the other teachers appointed person to the salary list dated so and so. Their service were regularized by creation of supernumerary post as per order dated so and so with effect from 1/9/2004, and that it was the petitioner who was appointed prior against the vacant post which was she was appointed, but subsequently when she was sent to the junior basic training post, another incumbent was appointed to the said post. Therefore, now with compliance with the Honorable High Court order dated so and so passing so the office chamber of the undersigned and conclusion arrived by the Honorable High Court have been taken into consideration. Accordingly, it is held that petition deputy does is entitled to be regularized by creation of supernumerary post, and department has sought concurrent finance department so. And thereafter, my lord, they annexure 152 is annexure 23, my lord. They has given my lord benefit, my lord, and they given as a secondary teacher.
No, what do you want now?
Now, my lord, they pass the order again, my lord, 156 month into their no salary, no any, my lord. Page 156.
You get your instructions are available?
Yes.
Page 156, my lord, your lordship.
156.
156. Pursuant to the government letter number so and so dated in compliance with Honorable High Court order so and so, this service deputy does so and so is hereby regularized with effect for 1/9/2004 to till occurrence as does regular against both so and so. They are all papers are already given, but they did not pay anything.
There appears to be no GPF account.
Yes, ma'am. Sometime. For this entire process.
Current salary, they are not paid.
How much time is required?
After 3 weeks.
Your account will have to be
Yes.
open for deduction of percentage to be put the GPF account. I heard counsel of the parties. The
The
sta-
notice may be issued.
May issue notice, madam, because there are other players for arrear salary also. It will take time.
in reference to the order part by the court, the standing counsel secondary education, elementary education as placed before the court. Her instructions, so according to the instructions received, it's seen that they submitted that the salary could not be released because of the non-availability of the GPF account number in the so the proposal has already been submitted by the BEO, Block Elementary Education Officer, the office of the Principal Accountant General within bracket ANE, get close Assam, for opening of the GPF account. So submitted that some further time be granted to complete the instructions with regard to the status of opening the GPF account. Considering submissions made, take notice issue, return 4 weeks. Mr. B. Gauhati, additional for state appears for respondent number 6, and this one also appears for the elementary education
Yes, madam.
1 to 5.
Yes.
Since the respondents are represented, notices of waive, extra copies be furnished in a period of 1 week from today. List the matter again after the returnable date. Tendency of the writ petition shall not be a bar for the respondents to redress the grievances of the writ petition.
Fix a date.
After 4 weeks,
One date maybe when other, no salary, no current salary.
you make a mention after 4 weeks if it is not listed.
Date no, otherwise.
17th August.
March.
Until 5.
This third round of litigation lordship, earlier the standing council was directed to obtain instruction as to what these steps they have taken in terms of the second round of court's order. Lordship will kindly see the order at page 73, 11 paragraph 5, 4 from 4 onwards.
70.
73, Lordship. MC, paragraph 5 onwards. May I read, Lordship? A plain reading of section 3111 shows that 3 teachers or tutors of whom at least one teacher for science and mathematics, social studies, language would mandatorily have to be appointed. For additional posts, the norms and standards provided in the schedule under norms section 19 and 25 of the right of children.
We should issue notice. I think you were asking for a direction to create an additional post.
No, already there is a direction, Lordship. But till
Then-
date, they have not taken it, Lordship, passed any decision.
Then you file a contempt. Why you file a?
No, Lordship, when they contempt the Lordship, the period that better one under collective consideration. In the meantime, the limitation period is over.
That is not a ground to file a second writ.
Lordship, page 76, Lordship. They are taking for some detailed report from the director. So that's what the last occasion they are now for directed to obtain instruction. What steps exactly they have taken, Lordship. But
If I'm awaiting my instructions, my lord, it's a motion matter. My lord will have it after 2 weeks, my lord, I'll get my instructions, my lord.
up-to-date instruction.
But the report says that lordship, there are more than 240, 50 students lordship. So one additional course is which is required to be filled out. Had it been done, lordship,
Your matter has already been decided by court in your favor. You sleep over it, did not proceed.
no, because
Now again, you are asking for a similar order.
now the consideration is that
Huh?
they have not come to a conclusion, lordship, in terms of this order. Lordship.
They have not come to a conclusion. There are other forums for you to pursue the matter.
So limitation is over in the meantime. Her report says, lordship, evidently, lordship, there are more than 250 students.
What orders have been passed? Any orders have been
No,
passed?
Lordship, as far as the orders, my lord, I have to get my up-to-date instruction.
Please do.
My lord, motion,
Get it after 2 weeks.
2 weeks.
Within 2 weeks.
my lord.
Mr. A. Deka for the petitioner, Mr. A. Fukan for the
Elementary education, my lord.
elementary education.
1 to 4 and one number 6.
Bearing for respondent 1 to 4 and 6. And Mr. Chaudhary for
7.
respondent 7. The respondent will obtain instructions as to the compliance of the order. Compliance of the directions at para 10 of the judgment and order dated 16/10/2023, passed in WPC number 6110 of 2023. Let these instructions be placed before the court by the next returnable date. Matter be listed on 17th August.
EPF. If the instruction is still awaited, lordship, kindly notice, lordship, I'll get the instruction as well.
Hmm?
I'll get the instruction, lordship, by then.
So this is case of non-payment of salary of my suspension.
Right, third, counsel for parties issued notice written in 4 weeks. Mr. D. Upamanyu, Leonard. Counsel appears for the higher
Yes, lordship,
education
all the respondents.
for all the respondents. Therefore, notice is away, the extra copy furnished within a period of 1 week. Today, matter be listed after the returnable date.
Outline, lordship.
Here I would like to file my affidavit, I have got the parawise for it. And in fact, the petitioners have been already protected by the earlier order dated 25/6. Lordship will see the last order. Last para of the last order.
You are permitted to file.
Now permitted to appear in the examination, if
Examination.
at all such an examination is conducted.
Examination is conducted.
No, my lordship, my concern is that my lordship, 26,
You have been allowed to appear.
my lordship. My concern is that college authorities are saying that I don't have that 6 months gap, my lordship, from first semester year to second year. That within that 6 months gap I didn't have. So therefore, that is the main concern which I have, my lordship. Because
Then I will file my
27
affidavit, Lordship will consider.
27th is the exam, my lordship. And 26th, they'll,
What do you want?
my lordship,
What do you want?
I may be allowed to sit in the exam.
That is already
Already
granted
granted.
by the earlier order. Have you not read the earlier
No, my
order?
lordship. Only for attendance, my lordship.
Huh?
Attendance, my lordship.
You have been permitted to submit the application and to appear in the examination. That's the clear order of the court. What more do you want?
As per my instruction, my lordship, with that order, my lordship, the petitioner went to the college authority. The college authorities have vehemently lectured him by saying that 6 months gap, my lordship.
You allow him to appear, Mr. Gogoi.
Well, that is the oral submission. There's
Ma'am,
nothing there in my.
27th is the exam and 26 eligibility list be out. If my name does not come there, my lordship, 27th I
Madam,
can.
I will file my affidavit by Friday, madam. Next week, Lordship will take up. It can be just not, madam. They require, my lord, requirement is, my lord, to have a 6 months period gap between one semester to the next. While, my lord, petitioner appeared in the first and the second semester, that 6 months gap is not there.
But they allowed us, my lord.
That's why, my lord, the homeopathy council has objected to that. So being the apex body, my lord, they have objected. Some, my lord, complications are going on in the homeopathy college. Not only the present petitioner, there are other petitions on this, in this regard. Even, my lord, 18 candidates who appeared in the fourth semester, all, my lord, entire examination was held to be nullified, null and void. And there was a direction for re-examination which has been stayed by the honorable. On that pleaded, my lord, it's not fault of the candidates. We have conducted the examination prior to 6 months. So let me file my affidavit, lordship will consider it when before 27. And the homeopathy council will have to come, my lord, before the honorable. And they are a party in the present.
27th is the exam, and 27th list will come.
You are appearing for
My lord, I appear for the health department as well as the college.
rules for the homeopathy.
Homeopathy is the central government.
They are not represented.
It's in the motion stage itself. That's why.
Any CGC here? And no CGC?
3 and 4.
For CGC. We'll take it up after a while. Let the CGC come.
And there is a provision for relaxation in the rules. We have
Where is
applied-
the homeopathy? National Commission for Homeopathy.
Yeah, 3 and 4.
We'll call up after a while. Let the CGC come.
Yes, Mr.
Yes.
First of all, I'm sorry, Lordship, my program. But I was broken, so I couldn't first thing. Lordship, I'm the in-charge headmaster of Bamunimoidam Junior Basic School, Lordship. And I joined in the service in the 1999 and I took charge as in-charge headmaster on 38/2025. Later on, what happened, Lordship, the private respondent had filed an WPC before your Lordship. And on the basis of the order, an inquiry was conducted by the department and held that my in-charge headmaster, I should be removed and she should be replaced. The thing is that, Lordship, while I was initially posted in Sonapur Junior Basic School, then I transferred to Bamunimoidam on my request, Lordship. On that point, I have lost my seniority and I am not on that lodge. The in-charge headmaster is a very responsible and position, Lordship, to uplift the school and environment of the school.
Let the, what do you say, government?
I am for the caveat.
Caveator.
Caveat.
The B Purcaster is for the caveat discharge.
As per, my
Who are
lord,
you? Who are you?
I am for the private respondent.
That we can see, but why? What is your grievance?
My goodness, I have been allowed to hold the charge because I am the senior most teacher of this school.
You are allowed to hold charge.
Yes.
Petitioner is not there.
No.
Petitioner is not. Because she has lost her seniority due to own request transfer.
All right, then we'll issue notice him.
Yes.
Heard?
But till then, Lordship, impugn order may be stayed.
My lord,
Lordship,
already is acted upon.
No, but
and I'm the senior most.
we'll make it subject to outcome of the
Yes.
petition. Because impugn order stayed will prevent her from becoming in charge.
Yes.
It will not automatically make you an in charge. Some other order will have to be passed. So the school cannot be without an in charge principal.
I'm working as in charge.
That cannot be my lord, because
Where is
her
that?
order is
Where
cancelled.
is the impugned order?
I have
Impugn order is that is 35 Lordship.
35.
order is
Order 39. 35 is the type of the
12/6.
12/6.
That charge has already been taken.
yes.
No, Lordship. Does not take.
How can you not give the charge? View of this
Because
order? What is the status?
But I'm in
Government? Get it by Friday. Friday, tell us who's holding charge.
page 91, my lord, can you see?
Friday, we'll take up, decide who's holding charge.
till
Based
then,
on Friday.
till then also.
Till then, nothing. On Friday, let us find out who's holding charge. Pass out the report.
Deeply applied.
Government will obtain instructions, apprise the court as to between the petitioner and private respondent number
5.
five, who's presently holding charge of the school concerned, as it is submitted by the council for the petitioner that he is not handed over charges of it for the post of in charge principal.
Bamuni Moidam, government basic, junior basics.
Samani Mudam, government junior basic schools.
Deeply applied.
Third, council for parties issue notice declaring for 4 weeks. It's for advocate appears for respondent number
156 and 10 lordship
156
and 10.
and 10. 11, 156 and 10. Council for secondary education, elementary. No, there is a department of education, school education is secondary.
Secondary as well as elementary.
Department of school education is elementary.
Sorry, and the member of government, both elementary, secondary.
So who will appear for department of school education?
I'm appearing.
Council appears for respondent number 2, 3, 4,
7.
not 7, 8, or 7,
7 and 8.
7, 8,
It's 9.
9. Huh? Not 4.
Confession and appointment itself is represented by the director.
SLC is by the government advocate. Right, number 4 is by the government advocate. Huh? If the respondent are represented, notice to be extra copy will be furnished within
One.
period of 1 week from today. Respondents may complete their instructions and file necessary evidence. List after 1. Oh, notice. 4 weeks.
And then 12.
Yes.
Studying as private secretaries method, they were given the benefit of MECP method by an order annexure 5, but the impugn order annexure 6 that has been withheld. That is under challenge.
Notice at this stage, our council for parties should notice. MS,
P. Upadhyay, lordship.
by the appears for respondent number 1, 2, and 3.
Yes, your lordship.
The respondent being represented, who formal notice be issued. However, extra copies be furnished within a period of 1 week from today. The respondents will in their instructions and file necessary affidavit.
Congratulations.
Signing item 7.
Yes, where is the CGC? Mr. Kaushik, this is a matter with regard to homeopathy council. Give him a copy. Why have you not served extra copies earlier?
Filing.
So this is the matter of homeopathy council.
Well.
So he required to appear for some semester examination, not being allowed because there is no gap of 6 months or how much month?
6 months.
6 months gap is not there.
Well.
So get your instructions.
Well.
The examination list is to be published on 26th.
26.
26th of
26 this month.
26th is a Sunday.
27th is the exam.
List will be published on Sunday.
As per instruction 26 before
26th is a Sunday. Or it,
Let it be on 20th.
20th. 20th,
20.
20.
It's a Monday, man.
You'll be able to get your instructions.
I'll try.
List on 20. For instructions by the learned CGC. Mr. B. Gogoi, appears additional AG appears for the health department who submits that he'd like to file his affidavit. Okay. List accordingly. The CGC, learned CGC has appeared on the request of the court as for to represent the National Commission for Homeopathy. Therefore, extra copies be furnished the learned CGC during the course of the day.
Highly obliged.
Great. Request for showing my name as respondent.
Registry will reflect the name of the Kaushik and the CGC.
Great.
For order, second copy.
We Google took 2 weeks time to take instruction as last.
D. Gogoi.
You lost.
Where is D. Gogoi?
Report order is at page 25.
D. Gogoi. Oh, he's in the forest somewhere. You have to call him out. D. Gogoi. After some time. Item number 14.
Second 15.
Some time will be required, Lordship.
Huh?
For some 2 weeks more time, Lordship.
So who's for the petitioner? None appears for the petitioner on call. Mr. A.R. Govindar appears for the. Here for the petitioner.
Higher education.
Higher education. Praise for further 2 weeks time. List again after 2 weeks.
All right.
Next. Yes, for the petitioners, my lord, appointed as my lord, visit teachers. Their appointment has been cancelled. My lord, on several occasions, my lord, this was served to restaurant number, my lord,
3.
my lord. But in spite of my lord getting notice, my lord, they have not appeared, my lord. It lord, kindly have a look to last order dated, my lord, 8/6/2026.
This is a school under which?
My lord, initially, my lord, this schools were under, my lord, RMSC, my lord. Thereafter, my lord, the school has been got under control of my lord Adarsh Vidyalaya Botany.
I'm appealing for number 3 for that autonomous body. I have received my instruction. I'll file my affidavit.
Counsel, Mr. Islam. J. Islam appears for the petitioner. Mr. SMT Chisti, learned counsel, submits that his instructions to represent respondent 3.
Yes, ma'am.
He received his instructions. He would like to file his necessary affidavit. Mr. Sharma for BTC. Anyone else?
And C is for second.
Huh?
Secondary respondent.
Respondent 7.
Second. Respondent 1, I have.
NSP Das appears for respondent number 1. And you are appearing on whose behalf? Mr. P. Naik appears on behalf of respondent 7. Since the respondents are represented, notices that the respondents will file their necessary affidavit. If not filed. In the meantime, matter will be listed for admission after 4 weeks.
Apply.
After 4 weeks. Noted.
Yeah, this is Lord. My lord, the elementary education department asked different study centers to recommend the teacher trainees for the purpose of DLED ODL boards course. In that view, my lord, the petitioners' institutions were also selected, and they were asked to take admission of various students. We took admissions after taking some lump sum money from them, and major portion of the amount has been given to the respondents. But they, all on a sudden, my lord, on 1/5/2022, they stopped the permission to get admitted the students in their institutions. All on a sudden, but already we have got admitted certain students. So for that purpose, we came to the Honorable High Court that the already got admitted students should be provided the benefit of teachers trainee courses under ODL board. Then Honorable High Court passed an order that Lordship may kindly say Annexure 1. Honorable High Court said that you file a representation that may be considered within 2 months. So accordingly, my lord, we submitted that, but surprisingly, the government did not do anything. Then we filed second application, second petition, and that second petition.
Where is the direction of the court?
Yes, that Lordship may kindly see page 17. Operative portion of the order is 17, 16 and 17. First, para 2 may kindly be seen, my lord. The state of Assam has adopted the scheme providing for study center for DL at board course for recommendation of teachers trainees for DL at ODL board course. So that was there. Then they all on a sudden stopped this on 1/5/2022, last portion of para 2. Then, my lord, the operative portion of the order which has been violated by the contemners, that Lordship may kindly see page 7, page 17, para 7. So they were given 2 months' time to take up our case for consideration, giving us the last chance. But we submitted the copy of this Honorable High Court's order on, my lord, it was submitted on 21/12/2023, page 19, my lord. Even then, they did not take any action. So under compelling circumstances, my lord, again it was submitted. Several times it was submitted, but they did not take any action. So we have filed this contempt petition. We have taken so many steps, several steps upon the respondents. First, it was taken on 14/3/24, then 15/3/24, then, my lord, on 20/12/24, then 17/11/25, and then 14/5/2026. So many times we have taken steps, but no response is coming from their side.
So
They have taken a huge amount from us, my lord. We have given them money by bank transaction. These are
Who's the counsel for the respondent?
the contempt case, my lord.
No one has appeared.
Someone has appeared sometime. Davis. But so many steps have been taken. There is no reason to disbelieve why they have not received the notice. So, my lord, if your lordship may be pleased to issue bail or warrant of arrest, then
Warrant. Who are the respondents here?
respondents are several persons, but the direction was to respondent contempt number 1.
And we are talking about the contempt petition.
Yes, one
How many respondents?
Here, two respondents, but earlier two has been replaced by 1. So now mainly 1.
There is only one respondent here.
Yes, one is here, Manjit Brahmo.
Uh, so 1 and 2. Yes, education department, who's there? Who's for the education department here? Yes, Mr. Bora. Steps have been taken apparently, whether they are served or not, we don't know. Please obtain the instructions from respondent 1 and 2. Heard Mr. M.U. Mahmood, learned counsel for the petitioner, Mr. K. Bora, learned standing counsel, represents respondent number 2, 1 and 2. Stop. Mr. Bora is requested by the court to enter appearances on behalf of the respondents since none had represented the respondents. Stop. None had represented the respondent in the present contempt proceedings. Stop. Notices in the matter was issued as far back as
Several times. 14-3, 15-3,
13
then
2024.
2012, 24.
Under such circumstances, the court had requested Mr. Bora to appear in the matter, represent the respondents. Mr. Bora will obtain required instructions and file necessary affidavit if this need so arises.
Let them provide it.
Mr. Bora will also apprise the court as to why the directions contained in the order dated so-and-so, passed in WPC so-and-so, has not been complied with. Since Mr. Bora has entered appearances today, counsel for the petitioner will ensure service of sufficient copies of the writ petition during the course of the day.
Contempt petition.
Contempt petition, along with all enclosures during the course of the day. List this matter again on 19th August.
Obliged.
That I've received the instruction. The SLC is scheduled on 24/7/2026. Did this matter come up after that meeting so that I can apprise this on the
Mr. B. Purvester for the petitioner, Mr. B. Kaushik. Counsel appearing for the elementary. Respond.
by the respondent 2 and respondent number 2.
Respondent 2, MSK Fukan for
Respondent number 3.
respondent 3. Mr. Kaushik submits that the SLC is scheduled to be held on
24/7/2026.
24/7,
2026.
2026, and therefore the matter be posted after that. Accordingly, let this matter be listed again on 5th of August. And the learned counsel will apprise the court with regard to any such decision that may have been arrived at by the SLC in its meeting scheduled to be held on 24/7.
Grateful.
Please, Your Lordship. In this matter, steps are not been completed. Further, 2 more weeks may be granted for completing steps.
Counsel for the petitioner prays for and is granted 2 weeks further time to take steps on the respondent. Mr. A. Fukan appears for
Elementary education.
elementary education, Mr. Boro for accountant general. Released after 2 weeks.
DPMS.
Your Lordship, kindly see the last order dated 26/11/2025.
It's not the last order.
Yes, the previous order, 26/11/2025.
No affidavit filed.
Yes, no affidavit filed.
What is your grievance?
Yes. My grievance is my service has been provincialized in the year 2021 with effect from 1/1/2021. Now, in the meantime, some 2 gentlemen has challenged my appointment before this honorable court. And this court was pleased to pass an order directing the respondent authorities to consider the matter and pass an speaking order with regard to who is entitled to the benefit of provincialization. Now, in that process, my lord, my provincialization order has been cancelled. That your order lordship will find at page 31. Their operative part lordship will find at page 34 the order portion, my lord. Page 34. May I read, my lord?
Yes.
Yes, 34 order. In view of the above facts and circumstances, as per the report of the DEO Dubli as well as the DICE verification report submitted by the SSA Assam, by name of the respondent number 7, Mokrom Ali, appeared in the DICE data against P. Basanipara LP School, bearing dashboard number so and so from so and so only. Thereafter, the name appeared against the Kochim Basanipara BLP School, bearing dash number so and so from 2010-2011. Hence, the provisionalization of the service of the order issued by order number so and so dated so and so, respondent number 7, Mokrom Ali against P. Basanipara School is hereby cancelled. Now, next one. On the other hand, the name of the petitioner Saadul Ahmed was not recommended by the DSC Dubli against the P. Basanipara LP School, bearing dashcode number so and so, and also his name was appeared in the dashcode data P. Basanipara School from 2009, 2012, 2013, which does not fulfill the decision of the Joint Committee minutes dated 24/7/2020, as his name does not appear in the DICE data from 2011-2012, and afterwards, as per the clause 1 of the Act 2017, the teacher should be appointed on or before 31/10/2010, and accordingly his name may be included in the DICE data at least 2010-2012. Hence, the service of the petitioner Shahadul Ahmed cannot be considered under.
Where is the order of the court pursuant to which you say the private
court-
respondent were
Yes,
appointed?
Court's order lordship will find at page 25. Page 25, my lord. My lord, page 27, may I read, my lord, paragraph 3, my lord?
No,
Sorry,
read the whole order. It's a,
Yes.
it's a small order.
Heard Mr. So-and-so, London Council for the petitioner, also heard Mr. and people so-and-so, the authorities under the elementary division of the person, the J.K. Pradhan, London, open advert for the respondent number 3, being the deputy commissioner Dubli and Mr. So-and-so for the respondent number 7. Petitioner number 1, Shahadul Ahmed, and petitioner number 2, Ismail Ali, claim to be the head teacher and teacher of the P. Basanipara Bansar LP School, the Dubli district, having been appointed in the year 2000 and 2003 respectively. According to the petitioners, the respondent number 7, Mokrom Ali, is a teacher of a different LP school, namely Kochim Basanipara Bansar LP School, having DICE data 2000 so. The petitioners claim that DICE code of Basanipara Bansar LP School, where they were serving in this so in the provincial process under the Assam 17, or the school of the petitioners, that is Basanipara Bansar LP School, having DICE data so was included in serial number 26 of the list of the schools recommended for the purpose of provincialization, but the names of the petitioners were included as eligible teachers, and this school of the petitioner was shown at 2041 number Andamari LP School, which was within a distance of 1.5 km from the petitioner's school. The respondent number 2, being the chairman of the state level scrutiny board for elementary education for the purpose of provincialization, had notified a district wise list of teachers for provincialization as per notification number so and so, dated 4/2/2021. As per the said list contained in the notification dated 4/2/2021, it is the name of the respondent number 7, Mokrom Ali, that appears at serial number 433 against the school name P. Basanipara Bansar LP School in the Bileshwara district. Mr. So-and-so, London Council for the respondent number 7, on the other hand, raises the contention that the notification containing the list of provincialized teachers for the name of the respondent number 7 is at serial number so and so is a correct depiction, and respondent number 7 was provincialized against the school in which he was teaching. The said statement has to be understood to mean that the respondent number 7 was provincialized against Paschim Basanipura LP School, Venture LP School, having dash code number so and so, considering the ambit of the dispute between the parties as to the whether the respondent number 7 was provincialized against the Paschim Basanipura Venture LP School, having dash code number so and so, against P Basanipura Venture LP School, having the dash code number so and so. We remand the matter back to the Director of Elementary Education Assam to call for the records verifying the respective dash codes of the two schools, namely Paschim Basanipura LP School and P Basanipura LP School, and also point out as to the which two schools were appointed and served, in which school the respondent number 7 was appointed and served. As it is an admitted case of the respondent number 7 that he is a teacher of Paschim Basanipura Venture LP School bearing dash code number so and so, the Director of Elementary Education, upon examining the records, he finds that the respondent number 7 was provincialized in a Paschim Basanipura LP School bearing dash code number so and so. Appropriate region order may be passed. In the event, the Director, upon examining the records, finds that the respondent number 7 was provincialized against the P Basanipura LP School having dash code number so and so. Appropriate order may be passed for removing the name of the respondent number 7 from the list of the provincialized teachers and pass necessary corrected order to bring the teachers of the P Basanipura LP School having dash code number so and so.
This is the, you are present in the matter. You agreed to this order.
Yes.
Then thereafter the evaluation took place
Yes.
and the director has passed the input order.
Input order. Now, while passing the input order, Director have gone beyond the order passed by the Honorable High Court.
Why?
High Court says who is the genuine teacher of that particular school. And in the course of the verification process, it is established that I am the only teacher who was serving in the said school.
This is not the direction. Direction is that you were provincialized against that Basanipura Venture School.
Yes.
Appropriate order may be passed by removing the name from the list of provincialized teachers. So, where is the order of the director?
Yes. Director order lordship will find at page 31.
Where is the original copy?
Yes. But we have annexed the original copy also. Page 37. May I read the order input here, page 31.
So this is the finding at page 37.
Yes, 37.
Second last paragraph from the bottom. You are found to be, your name appears against dice code in Paschim Basanipura,
Yes.
but you were regularized in dice code number under in Paschim Basanipura VLP school, having dice code number so and so from 2006-7 to 9-10. But your name appears only from 2010-11.
No, my lord, 6-7. 6-7.
No, this is the finding. This is the finding.
Now, finding lordship, kindly see, my lord, page 34, type copy, my lord. In view of the above facts and circumstances, as per report of the DO, Dubri, as well as the dice verification report submitted by the SSA Assam, respondent number 7, Mokromali, appeared dice data against P Basanipura LP School, bearing dash code number so and so from 2006, 2007 to 2009, 2010 only. Thereafter, the name appeared against the Paschim Basanipara LP school bearing dash code number so and so so and so. Initially, 6-7 to 9-10, then 10-11. Hence, the provincialization of the service order so and so dated so and so Mukhrupali against the P. Basanipara school is cancelled. Now, what is the justification? My name appeared in the dash code with effect from 2006 and requirement is 9 and 10. Dash data should be 9 and 10. My name appeared with effect from 6-7 to 9 and 10 and subsequently also 10 and 11. Then thereafter. On the other hand, the name of the petitioner Shahadul, I am not the Shahadul, he is the lead petitioner, Lordship has seen earlier, was not recommended by the DSC. I was recommended by the DSC. Dubri against P. Basanipara school bearing dash code number so and so, and also his name was appeared in the dash data against P. Basanipara LP school from 2012 and 13. Shahadul name was appeared in the dash data 2012 and 13, which is not fulfilled the condition as per section 2S, because the dash code's name must be entered in the year 2009-2010 at least. Now his name appeared 2012-2013, which does not fulfill the decision of the joint committee minutes dated so and so, and his name does not appear in the dash data from 2011-12 afterwards. As per section 2(1) of the Act 2017, the teacher should be appointed prior to so and so, and accordingly his name may be included in the dash data against so and so. Hence, the service of the petitioner Shahadul cannot be considered under the provision of section so and so is hereby rejected. That is fine. Shahadul name was not appeared, he was not considered. But what about me, my lord? My name appeared. My name was recommended by the DLC, District Scrutiny Committee, again, my lord, State Scrutiny Committee, and subsequently my service has been provincialized. My provincialization has been, my lord, cancelled.
What is the stand of the respondents?
My lord, since no
No
affidavit has been filed.
May I just point out? Take your lordship to the earlier order of this. Lordship comes to page 27. The dispute was with regard to the dice number. Your lordship will find there are two dice number of the same school. Of the name of the schools are same. And it is paragraph 3 million, from paragraph 3 million, may I read it? According to the petitioner, the respondent number 7, Mokram Malik, who is the petitioner here, is a teacher of a different LP school, namely so and so, having dice code number 0416342. My lord will kindly see 342 is the last. The petitioner claims that the dice code of so and so, where they are serving, is 322. In the provincialization process under so and so, the school of the petitioner did, that is P. Basanipara Bensar LP school, having dice code number 322, was included at serial number 26 on the list of the schools recommended for the purpose of provincialization, wherein the names of the petitioners were included as eligible teachers, and the base school of the petitioner was shown as 2041 number Anandamari LP school, which was within a distance of 1.5 km from the petitioner school. The respondent number 2 being the chairman of the state level scrutiny committee for elementary, for the purpose of provincialization, and notified a district-wise list of teachers for provincialization as per notification dated 4/2/2021. As per the state list contained in the notification, it is the name of the respondent number 7. My lord kindly finds it. Name of the respondent number 7 that appears at serial number 433 against the school name P. Basanipara LP school in the Bilasipara district. So and so learned counsel for the respondent number 7, on the other hand, raises a contention that the notification containing the list of provincialized teachers, wherein the respondent number 7 is serial number 433, is a correct depiction, and the respondent number 7 was provincialized against the school in which he was teaching. The statement has to be understood to mean that the respondent number 7 was provincialized against Paschim Basanipara Bensar LP school, having dice code number 041342. Well, he claims to be a teacher of this school bearing the dice code number 342. Now, paragraph 6. as it is an admitted case of the respondent number 7 that he is a teacher of so and so bearing dice code number 342, the director elementary education upon examining the report, if finds that the respondent number 7 was provincialized in Paschim Bhasanipura LP school bearing dice code number 342, appropriate reason order may be passed. In the event,
What appropriate reason order?
Malad, confirming his provincialization, if he is found to be provincialized for the school which bears the dice code number of 342, since in the list of provincialization only the name of the school was mentioned. So this was the exercise to be undertaken by the director Malad to verify whether the school against which the respondent number 7 was provincialized bears the dice code number 342 or the dice code number 322. If I read further, Miller, in the event the director upon examining the record finds that the respondent number 7 was provincialized against P. Bhasanipura LP school having dice code number 322, appropriate order may be passed for removing the name of the respondent from the list. So, if your lordship kindly turns to the speaking order, Miller, there is no infirmity in the decision making process, Miller. Lordship kindly comes to paragraph page 33, Miller.
Yes.
Miller, from the second last paragraph. In compliance of the Honorable High Court's order dated so and so, this office issued a letter to the DO Dhubri to verify the matter, and accordingly DO Dhubri submitted a report wherein stated that Mokram Ali was a teacher of P. Bhasanipura LP school having dice code number 322 from 2006 to 7 and 2009 to 10, but his name appears against the dice code number 342 of Bhasanipura LP school from 10 to 11 onwards. On the other hand, Sadullah Khan and Kismat Ali are the teachers of Bhasanipura LP school having dice code number 322 with effect from 2013, 12 and 13. As per dice verification report submitted by the SSA, while later dated so and so, where it appears that respondent number Mukram Ali was a teacher of P. Bhasanipura PLP school bearing dice code number 322, and his name was appeared in the dice data from 2006 to 7 and 9 to 10 against P. Bhasanipura BLP school. Thereafter, from 2010 to 11, his name appeared against P. Bhasanipura BLP school dice code number 342. On the other hand, the name of the petitioner so and so is appeared in the dice data of P. Bhasanipura bearing dice code number 322 from 2012 to 13 and so and up to 20.
How many schools are there?
So there are two schools of the same name with the different dice.
Same name.
Same name. Now his claim is he initially claimed that he was provincialized against the dice
322.
342.
342.
His case, his admitted case was that he is a teacher of Bhasanipura LP school bearing dice code number ending with 342.
342.
Now his name was found against the dice code number 322 prior 2019. Whereas his provincialization is done against the school bearing 342.
So,
and accordingly, well, now since there was a direction from this honorable court, if it is found that his name is being provincialized against the school 322, his name has to be removed from the list. And accordingly, it was removed. And there is no material in the.
What about 342? What about 342?
342, my lord, 342 here.
He was. It's an admitted case that he was a teacher of 342.
342.
So,
but the provincialization order
in 322.
So yes, but the provincialization order was issued against 322. Now there, in this repetition, he has not placed any record to show that this finding of the authorities is perverse.
Show the report then. The report on the basis of weight.
Now, Lordship.
The SSS verification.
Now,
The
Lordship,
report of the DO. Dhubri.
and the SSS verification.
Huh.
Because there are the SSA DICE verification report was submitted on 29/7/2022. That was relied upon by the director while passing. I'll get.
Now, Lordship, kindly see for a moment, my lord, page 19. That is the, my lord, inconsistent, my lord, submissions, contrary to the records. Lordship, kindly see page 19. Page 19, Annexure 3. Lordship will find, you have given the type copy as well as the, my lord, original copy also. Lordship will find, my lord, school code 322. Lordship has seen. Page 19, serial number 1. 6322.
Yes.
2009-2010. Lordship will find my name, name of the teacher, Ainobi and Malad Mokromani. Lordship has seen. Serial number 1, page 19.
Then?
Yes. Then again, serial number 2, Lordship will find 342 dash code. 342, last 3 digit, my lord. There Lordship will find my name, Mokromali. Again, my lord, serial number 3, 342, Lordship will find 2019-20 dash code, Mokromali, petitioner here. Then, my lord, the original, my lord, from downloaded from the, my lord, website, Lordship will find page 21. Teachers database as per DICE of P. Basanipara LP School. Dash code number, Lordship will kindly see, there is a 2 dash code number. 322, and again, my lord, Paschim Basanipara LP School, dash code number 342. Now, Lordship, kindly see the same situation. My lord, dash code number 322, Mokromali, petitioner here.
No, come to this page number 21.
21, my lord. Yes,
Against DICE code 322.
my lord.
There is one Mokromali.
Mokromali, petitioner.
His date of birth is 1/3/1971.
1970.
My lord.
70.
Yes,
Then 342, another Mokromali.
yes.
His date of birth is 1/3/73.
1373. Yes,
So which Mokromali are you?
yes. Lord, 1370 and 1373. That may be, my lord, some, my lord, typical error maybe.
We don't
It is-
know.
It is, my lord,
This is
data.
for your document.
It is database submitted by the
You are
respondent.
saying both are one and the same.
Let them verify.
You know that.
How
How will they verify? You tell us.
Yes.
Which one of these two are you?
Now, date of birth is wrongly, my lord, written. Yes, I'll furnish this, my lord, correct date of birth.
Huh?
That is no problem, my lord. Next, Lordship, kindly see page, my lord, same page, my lord. Serial number 3. Again, my lord, 342. Last digit, my lord. Lordship will find again Mokromali. Here again, my lord, date of birth 1373.
What is your date of birth?
Yes.
from the affidavit of this repetition, it appears he is none of this. He's 38 years.
Appears to be.
Yes, I'll furnish the, my lord, copy of the, my lord, SSA admit card. That date would be, my lord, mentioned.
You have already given date at page 14, your affidavit.
That
You say you're 38 years old.
that is, my lord, approximate age is given.
So how can it be approximate for a
Yes,
strong picture?
53 and 56, 38 cannot be an approximate.
You were born in 96.
We'll furnish the, my lord,
One Mokromali is born in 70, another is 73. You are neither.
my lord, will furnish the, my lord, admit card. That will reveal, my lord, what will be date of birth.
No, revealing it before this court is not going to help you. You'll have to get this corrected. If according to you, you are either of these, you can't say which Mokromali are you. Or you are not even saying that both the Mokromalis are one and the same.
That is, yes, that is, my lord,
And the schools are also same. That's also not
that is
taken.
from the, my lord, admit card, it will be clear, my lord.
Admit card will give an age.
Yes.
Before that, you tell us in page 21,
Yes.
there are two Mokromalis. Are they one and the same? or there are two different Mokromal.
Same Mokromal.
Same Mokromal.
Same Mokromal.
But having two different dates, date of birth.
That is why, my lord, I will produce the, my lord, admit card of the SLC exam. That will, my lord, substantiate.
It already finds some additional affidavit.
That is regarding, my lord, service of the, my lord, private respondent. They are not appearing, my lord. The service was taken, and accordingly, my lord, additional affidavit has been filed.
Heard Mr. M. U. Mondal, Learned Counsel for the petitioner, Mr. B. Kaushik, Learned Counsel appearing for the elementary education. The petitioner is aggrieved by the order dated 31 May 2024, passed by the Director of Elementary Education, whereby the provincialization of the writ petitioner against P. Asanipara VLP School, bearing dice code number 04163442. Which was cancelled?
My lord,
Page 38.
page 23 was cancelled, my lord. My provincialization order. Page 23.
Provincialization order number so and so, dated 5/2/2021, in respect of the writ petitioner against P. Bhasanipara VLP School was cancelled. Being agreed, the present writ petition is before this court. During the course of the hearing, the counsel for the petitioner submits that earlier the coordinate bench by order dated 5/8/2022 passed in WPC 1007 of 2021, filed by the private respondents number 7 and 8. Private respondents number 10 and 11 as the writ petitioners, in which the present writ petitioner was arrayed as a private respondent. Directed the Director Elementary Education to examine the claims of the parties and by calling for the relevant records and thereafter pass appropriate orders. Stop the said order. The coordinate bench had recorded that the respondent number 7, namely present petitioner, is a teacher of Paschim Asanipara Venture LP School, bearing dice code number 04163442. Stop. The writ petition was disposed of, directing the Director Elementary Education to examine the matter, and if it was found that the provincialization of the respondent 7 therein within bracket present writ petitioner is against the Paschim Hasanipara Venture LP School, bearing dice code number 04163442, then appropriate orders be passed, reasoned orders be passed. However, in the event it is found that the said respondent 7 within bracket the present writ petitioner was provincialized against P. Hasanipara Venture LP School, bearing dice code number 04163322. Then appropriate orders be passed, removing the name of the said respondent 7 within bracket petitioner herein from the list of provincialized teachers, and pass necessary corrected order to bring the teachers of P. Hasanipara Venture LP School, having dice code number 04163222 in the list of provincialized teachers. Stop. Where are the counsel for the petitioner, by referring to the said order dated so and so, passed by the coordinate bench, submits that the impugned order passed by the Director Elementary Education was beyond the directions issued by the court, and the provincialization order of the writ petitioner was wrongly cancelled. Stop. Upon careful examination of the materials before the court, seen that the teacher database as per the dice of dice of P Bhasanipara VLP within bracket dice code number 416322 and Poschim Bhasanipara VLP school bearing dice number 041634 of the Bilashipara block of Dhuri reflects the following information, page 21 to extra review. From the perusal of this information available before the court, it is seen that in P Bhasanipara VLP school bearing dice number 041632, as also in respect of Poschim Bhasanipara VLP school bearing dice number 041642, the name of Mokram Ali appears in the list of teachers. Stop. The name of Mokram Ali in P Bhasanipara VLP school bearing dice number 041632 is shown to have a date of birth of 1/3/1970, whereas Mokram Ali, who is shown as whose name is reflected in Poschim Bhasanipara VLP school bearing dice number 041632 is shown as his date of birth is shown as 1/3/1973. Stop. Here on a pointed query to the counsel for the petitioner as to which of these two represents the petitioner, the counsel submits that both the names belong to the petitioner. So this, however, also is contrary to the age reflected in the affidavit filed by the writ petitioner in support of the present writ petition, where the age is shown to be 38 years. In which case, the petitioner's year of birth would be 1996 and not 1970 or 1973. Stop. Well, the learned counsel before the court therefore submits that you would like to place further materials in support of his contentions regarding correct date of birth before this court. Praise for 2 weeks' time. Let this information be placed before the court by way of an additional affidavit, released after 2 weeks. Mr. B. Kaushik appears for the private respondent. Elementary unit. Huh?
Let this matter be come up after 2 weeks.
Preferred an appeal.
But that submission has been made from long back.
What is the status of the appeal?
That's the appeal is
Delay.
effective. It's
Delay.
delay and defect. There is a
Not what happened with this appeal lawsuit. They filed the appeal in the month of February. That appeal is lying in the defective lawsuit. They have not rectified. Although barely because the appeal is filed, whether this content lawsuit, there is a latest Supreme Court decision lawsuit. Just I'm relying lawsuit to paragraph or short paragraph lawsuit. Paragraph 27 to 30.
very correctly identified. So
May I just brief?
this is not only just a finding, but a direction also.
Yes.
Where the High Court should deal with it very sternly.
May I just pray for 2 weeks as a final last?
All right, 2 weeks and no further. We'll pass orders after that. Mr. B. Kaushik, learned CGC,
Yes, sir.
learned counsel representing the
Press for
respondent.
number 1.
1 submits that against the judgment and order dated 2/9/25,
My lord.
passed in WBC 5817 of 24. An appeal has been preferred, but order has been passed by the division bench on the said appeal as yet. Prays for further 2 weeks' time to complete his instructions. Better. Mr. M. Khan, learned counsel appearing for the petitioner on the other end, submits that the respondents have filed an appeal simply to disobey the implementation of the directions of the courts. The appeal was filed long back, however, no such order has been passed, and as per the information received by the petitioner, it is still lying in defective. So he has placed before the court a judgment of the apex court rendered in Israr Ahmed Khan versus so-and-so, reported in 2026 SCC online SC 322. To submit that such attempt to delay or defeat the justice or implementation of the directions of the court's order have been sternly dealt with by the apex court, and liberty is granted to the high courts to deal with such matters in strictest terms. Having considered the submission made and upon perusal of the judgment placed before the court, purely for the ends of justice, we permit further 2 weeks' time the respondents to comply, to apprise the court with regard to the status of the appeal stated to have been filed. It is made clear that in the event no such order is passed by the appellate court, then the court may proceed with the present contempt proceedings. This matter began on 7th of February, 7th of August.
Grateful. Here I am in violation of a direction of this honorable court at page 30, 24.
Respondents are represented.
Yes, sir.
Yes,
And we have filed our appeal.
you have filed. Where is the direction of the court?
That is at page 108. Now, but since this order has not been complied, but the direction of this honorable court in the earlier round of litigation, that also could not be complied. That your lordship will find at page 21. What happened, my lord, the petitioner initially filed a writ petition along with some other petitioners for regularization of their services. While this repetition was pending, he was terminated from his service without any inquiry. In the writ petition where he has paid for regularization, there was a direction for regularizing the service. Since he was terminated, now this order has also not been complied. Page 21, paragraph 9.
So what is the stand taken in the affidavit? Where is the affidavit?
That as per my senior instruction, already filed it.
When did you file it?
Before holidays. ma'am.
Who is your senior?
Mr. PJ Pukun. Mr. PJ Pukun. He is before order number 1. I have not been served with any copy.
Mr. B. Kaushik, learned counsel, appears for the petitioner. Mr.
R.A. Sheikh. R.A. Sheikh.
R.A. Sheikh appears on behalf of Mr. P.J. Fukon to submit that an affidavit on behalf of the respondent has been filed. When?
Before vacation.
Before the ensuing, before the summer vacations. Stop. The office note does not reflect that any such affidavit has been filed, nor is any copy of the affidavit available. Stop. Counsel for the petitioner also submits that the no copy of the affidavit has been served. So under such circumstances, the registry will trace out the affidavit stated to have been filed by the respondent and make necessary endorsements. Is this matter again after 1 week?
Great.
Non-compliance of order to purchase is for 49 also.
49.
Case 52.
Where is the direction?
Under the given text, this court is inclined to dispose of this petition by directing the Director of Secondary Education, Assam, Kailipara, Gauhati, that is respond number 3, to make necessary verification of the service particulars of the petitioner. And in the event of being found the petitioner similarly situated like those of the petitioner in WP so and so, then to grant similar reliefs to him, which were granted to the petitioners in those petitions. The exercise has to be carried out within a period of 3 months from the date of receipt of a certificate copy of the law.
Service is awaited.
As per the office note, usual process has been completed.
So that since service by speed post is there,
Usual process has been served.
as per office note dated 2/7/26, service report on the sole respondent by speed post has not been received back. Accordingly, although service by usual process has been received. This matter therefore be listed again after 4 weeks.
Can it be placed for the Lozima court so the postal take consent?
Registry will put up the matter before the Lozima court for passing appropriate orders, and the matter be listed thereafter.
Lordship, service is complete in this matter. Lordship, may kindly pay the previous order. Lordship is regarding non-compliant.
Wakalatnama has been filed. Who is appearing on behalf of respondent? Wakalatnama to say, are you appearing? Where is Mr. M.J. Khatuni?
After some time.
After some time. You're sure he is appearing?
He will appear.
Okay. After some time. Any affidavits being filed?
No.
All right, let him come after some time. Get a Wakalatnama to sign violation. Second file. 25. Service awaited on respondent 7. Any counsel appears? On respondent 7?
Lordship, we have received an instruction that petition has expired, petition. Substitution also.
Counsel for the petitioner submits which writ petitioner? Only one petitioner
1069.
has expired in the meantime. Therefore, we'd like to complete the instructions. Because steps are to be taken for substitution. Released up to 4 weeks.
DPF
Mr. Fukan appears for respondent number
My lord, one.
1.
DPF.
Yes, yes, Lordship. The first case, in the writ petition, Lordship, government have to file an affidavit.
No,
Lordship.
there is an IA for
Yes,
impleadment.
IA for impleadment, Lordship,
Huh.
they have filed.
I filed for impleading. As a-
Impleading. Who are you?
I'm the principal.
Why do you want to be impleaded?
Because Lordship, as per he has been terminated as per our complaint. So I am the necessary party. Yes.
All right, heard. And it comes
May,
to
may
the
please, Lordship.
petitioner.
Lordship, we have filed an objection, Lordship.
You have
Yes.
filed objections.
Yes, Lordship, we have an objection. He is not a complainant. Lordship. Lordship, in this case, we have challenged the order, speaking order of the disciplinary committee. I have removed from the service, Lordship. He is not connected with this case, Lordship. Neither he is a disciplinary authority, nothing, Lordship. Unnecessary delaying the proceeding. Kindly see my objection, Lordship. I am removed from service, Lordship, without any show cause, anything, Lordship. That part is pending, Lordship, for immediate decision, Lordship. Already directed to file an affidavit to the government, Lordship. We have challenged the speaking order passed by the disciplinary authority. How is conducted, Lordship?
Who are you?
I'm the
The
principal.
in-charge principal, Lordship.
Principal. How are you a relevant necessary
Nothing,
party
Lordship.
here?
Anything.
On previous petition, I was also impeded, and in that petition, they had filed. Lordship,
This is a suspension.
I will satisfy your Lordship.
Satisfy.
Kindly next statement.
What next day? Why next day?
Last occasion he took time, Lordship.
Why you are not ready today? Monday? Monday. On the request made on behalf of the council for the applicant in IA number 1414 of 26, please release this matter on Monday, which is 20. Monday, if you can't satisfy us, we are dismissing your application.
Lordship, here in this matter, the instruction is awaited, Lordship. I'm paying for some time to obtain my instruction.
On the other hand, next minor, same issue, minor.
Similar order.
Same issue was decided by the base 27 minor.
Who's respondent 4?
Respondent minor. Same respondent.
The respondent 4 service is awaited.
That is the formal party minor. I am completed the course from that minor from the respondent.
But notice is issued, service will have to be returned. AD card unserved notice not received. Wait for some time. Fine. As per office note dated 9/7/2026, AD card nor unserved notice has not been received in respect of respondent number 4. Registry to place the matter before the Lozama court and thereafter pass appropriate orders thereon regarding the service of notice on respondent number 4. And matter thereafter be placed before
The 150 maybe.
Yes.
the other respondents may file their counter affidavit in the meantime, if so advised.
Much.
Thank you.
Respondent. Forest. So the petitioner here. Mr. B. Raman. Release this matter again on Monday, 20. As none represents the respondents. Mr. B. Raman appears for the petition. Yes.
In
What
24
instructions?
minutes, I'm praying for some more time, madam. I'll file my response, madam.
How much time?
3 weeks, madam.
3 weeks.
I'll file my response, madam.
Mr.
P. Khatoniar.
E. Khatoniar.
Alright.
Yes, for the petitioner, Mr. N. K. Khatoniar reviews for the private respondent. Sorry,
Sole
respondent
respondent.
submits that see this. You have received your instructions
Yes, madam.
and you'd like to bring it on record by way of an affidavit. He prays for 3 weeks for the time. Released again after 3 weeks.
So may I pay for date, any date?
7th August.
Obliged.
7 or 14th August. It'll be 14th August, 3 weeks.
You have complied, my lord.
You have complied.
My lord. My lord. Your representation has been rejected now.
Where is the direction here?
My lord, 8/6/2026, my lord, order dated, my lord.
Para 7 receive their direction to dispose of their representation receive. Para 7.
By order dated 23/4/2025, passed in WPC number 2067/25, the following direction was issued. There are 7. Stop. There are, since this direction was not complied with, the present contempt petition was filed. During the pendency of the petition, it is submitted that the representation was disposed of by order dated order
Credited
23/6.
23/6/2026.
26/2026. Passed by the Commissioner and Secretary to the Government of Assam, Department of School Education. Whereby the representations to rejected. A copy of the said order passed is placed before the court, which is kept in the case record. That view of the matter. The court does not wish to proceed any further in the contempt petition. According to the same stands closed. Notices if issued stand recalled, disposed.
I'm agreeing for both the respondents.
Mr. Bora appears for both the respondents. Mr. Chisti?
Yes, same.
All right.
Obliged.
I think
The relevant portion that page 58 of the paragraph 14.
Paragraph
14 Lordship.
page
58.
58.
Being considered the above judgment and order, and also considering that the petitioners are the regular petitioners among the petitioners, I am of the view that the present petitioners are entitled to be granted the similar relief as provided in the above judgment and order, and the consequential order of the respondent authority by the order of the 10/10/2020 by granting enhanced scale of pay with retrospective effect from 1/3/1999. Consequently, with respectable agreement and other judicial discipline, the petitioners are granted the similar relief as provided in the judgment and order dated 6/3/17 passed in WPC so and so, as well as consequential relief provided to the petitioners in the above writ petition by order dated 10/10/2022 issued by the Secretary to the Government of Assam. The respondent authorities are directed to consider and pass reason order by granting enhanced scale of pay with retrospective effect from 1/3/1999 within a period of 2 months.
In this matter, madam, some time is required, madam. I am appearing on behalf of P.N. Sharma, but he is not available today in the court, madam, due to his personal problem, madam. So,
Yes.
Lordship, in this case, I need some time to get the complete instruction in this matter. What is the status of that?
So you are appearing in the matter.
Lordship, I am listening.
Right. Get the status. Mr. S. K. Das for the petitioner, Mr. Sharma against all the respondents.
Lordship.
All. You are sure you are appearing in the matter?
Lordship, yes.
The learned counsel for the respondents will apprise the court as to why the directions contained in the order dated so and so passed in WPC so and so case number 59 has not been complied with. This relist again after 2 weeks.
Can it be 4 weeks, Lordship?
4 weeks? Why?
Yeah, I'll have to. 3 weeks, Lordship.
3 weeks, 14th of August.
Lordship.
14th of August. Page 64 also, 11%, same judgment, almost
Same. Same respondents.
same respondent.
Yes, Mr. Sharma. Mr. P.P. Sharma, you are appearing in this matter also.
That's the number.
Get your instructions in this, similar orders.
Some personal.
Where is the order? Where is the direction of the
I'm
court?
not here.
Lordship, page 58 also. Page 63 also.
64.
Page 64 also.
Yes, 64. Same order, same date. 14.
Lordship, some other councils.
So other council has appeared.
Their names are.
See, you are there, we are recording your name.
Lordship.
Who's appearing? Mr. Chisti?
Exactly. No, there's some personal.
No, this is the same respondent, same similar type of order, therefore we are recording your name. Next.
And the partner will get.
No, we are recording his name. only.
Yes, it's not.
Yes,
Lordship, same date on 14 August.
same date, 14 August.
All right.
Lordship, in this case, the BTC has filed the affidavit today itself. So the affidavit will not be on record, Lordship. We have sent a copy to the petitioner.
NSK is here for the petitioner, Mr.
NR Sharma.
NR Sharma appearing for the BTC. Submits that the BTC authorities have filed an affidavit today during the course of the day. Have you received copies?
Today.
Would you like to file rejoinder? The matter be relisted again after 3 weeks, by which time the petitioners may file their rejoinder affidavit, if so advised in the meantime. Registry will trace out the affidavit, will connect the affidavit stated to be filed by the BTC today. The case record. Released after 3 weeks.
That is not here, Lordship.
Hmm?
It's for arbitrator's approval, Lordship. 25/6 it was sent, but the report is not yet received.
What report?
That whether arbitrator will accept it or not, Lordship. Yeah.
By the earlier order, by the earlier order dated 19/6/2026, Justice Vasudev Agarwal, former judge of the Gauhati High Court, is appointed as a sole arbitrator, subject to stop. A copy of this order was directed to be communicated Justice Agarwal, and upon receipt of a written declaration as required under Section 12(1) of the Arbitration and Conciliation Act 1996, the appointment will be confirmed. Stop. However, from the office note, it is seen that the order was communicated on 25/06/26, and the written declaration is not yet received. Released again after 2 weeks on 7th of August.
The petitioner has been receiving her provisional pension from 2012.
I please, Lordship. I'm
For
appearing on
finalization of pension, my lord.
behalf-
Lordship, direct the authority to consider and pass.
Yes.
Well, I'm appearing on behalf of the Director of Pension, my lord. Some time may be granted to take instruction, my lord, where I have communicated it.
Last
Due to the
operation of-
vacation, my lord. Not received. 1 week or 10 days time is enough for taking the instruction.
Mr. N. Sharma for the petitioner, Mr. Sharma, D.K. Sharma appears for respondent number
4.
4. He submits that he would like to complete his instructions and brief for 2 weeks' time. NSP Das for
I'm appearing for 1, 2, and 3.
1, 2, and 3. Ms. Sharma for 5. Release this matter again after 2 weeks on 7th of August.
Yes, my lord.
All right.
Yes.
Maybe it's a lawsuit. In this case, my lord, earlier, my lord, petitioner was appointed in 1986, and there's one private.
We have already passed provincialization order, my lord.
Huh?
And my lord,
We have challenged the provincialization because order was passed in 2022, saying that 45 days was given to provincialize my service. They have provincialized my service on 16/10/2025, my lord. Instead of 45 days, they have taken 3-4 years. So we are saying benefit from the date of judgment of this court. Only 1 month the petitioner got due to their delay, my lord. After that, he retired from that.
Where is the order?
Order, my lord, page 43, 42, 43 is the order dated 9/5/2022. My lord, relevant portion, page 50, paragraph 15. Order was passed on 9/5/2022. By which the provincialization of private respondent number 6 was set aside. And
directed to provincialize my service in place of him, my lord. And they have, my lord, cancelled the provincialization of private respondent number 6, my lord, page 52. "45 days was given. Page 52, they have immediately on 17 September 22, they have cancelled the private provincialization of private respondent. But my provincialization was done on 16/10/2025. They have very immediately they have cancelled the private provincialization of private respondent. 17 September 22. But I have not got anything. Just before 1 month of my retirement, they have provincialized my sector. Contempt was also being. S54 is my provincialization. Now, what do you want? I my praying submission is, my lord, my benefit from the date of judgment, because due to their delay, my lord. No, that you should have. There is no specific direction.
Yes.
But my lord, 45 days was given. No, 45 days means will not amount to date of the judgment. But my lord, page 52. Then you filed a contempt. What happened in the contempt? In contempt, my lord, that they have they have thrown my provincialized my service from, my lord, 16 October 2025. Now, what do you want? I am want, my lord, the financial benefit. What benefit? Salary? Salary, my lord. From the date of judgment. Because date of judgment. That date of judgment will have to be reflected in that order on the basis of which you are claiming. It's not there. But my lord, one thing, my lord, now passing any further order to that will amount to review of that order. My lord, page 52. They, after passing this order, my lord, by this order, my lord, they have cancelled the provincialization. 17 September 22. But why not my provincialization was done? They have half part of the order they have done. They have cancelled the provincialization in terms of the order. Why my provincialization? Because salary, he is also not getting salary from September 20. The person whose provincialization was cancelled. It is not a case, my lord, that his provincialization was done, his provincialization was cancelled when my provincialization. That will amount to going into the judgment to find out the intent of the judgment. To go and file a review saying that the direction has to be given retrospective effect. My lord, contempt also, the liberty was given, my lord. You go and file a review. Liberty is given to challenge. Challenge, my lord. Because, my lord, due to their delay, contempt, liberty being granted, the contempt court did not go into the merits of the case to decide whether my submission, your submission we have understood. But the question is that you are asking now for retrospective benefit. Yes, ma'am. From the date of the judgment, or at least from the date of cancellation. Cancellation. Right? So that will lead to reopening the judgment. To understand that the spirit of the judgment is to give you the benefit with effect from the date of the judgment or within at least 45 days from the date of the judgment. That amounts to a review. There is, you point out any paragraph in the judgment which gives an indication that your benefit will be with effect from the date of the judgment or in effect from the date of the particular uh, directions period indicated. Show us from any particular paragraph. Respondent number 6.
Was, his service was provincialized on one.
You pointed out some cancellation order.
My lord,
Where is that?
there's page 52.
52 is cancellation of whom? The respondent.
Respondent number 6.
That is not even required. You come to page number 50. That order of respondent number 6 was set aside.
Yes.
So where is the question for cancellation?
They have cancelled.
They have cancelled, so that was not required. Now merely because they have issued an order, it doesn't give you any right, because the order of the private respondent has been cancelled.
Yes.
Was there any appeal filed
No.
by the private respondent? No. He appeared before the court.
If appeal filed, the appeal was dismissed.
Dismissed.
So I submit whether I can suffer due to delay matter caused by the respondent.
Examine that.
No affidavit also.
Heard counsel for parties. What notice issued here?
Notice issued.
The grievance of the petitioner is that the benefits directed to be benefit granted by the court by judgment and order dated 9/5/2022 passed in WPC number 5702 of 2021, whereby court interfered with the provincialization order passed in favor of the private respondent number 6 therein was set aside, and a further direction was issued to the respondent authorities to consider the case of the petitioner for provincialization of the language teacher. Now, I don't think we need to see the wording in the judgment. The direction is to consider the case.
Yes.
They have considered your case. They passed an appropriate order. What more do you
consider in 2025?
No. That interpretation is not called for. If you are willing to file a review, you won't file a review. But this is not, we can't go on endless litigation.
My lord, may I further sometime some judgment?
No judgment is required. You file a review to recall the finding of the court to consider your provincialization. Direction is to consider. Direction is not to provincialize you. Direction is to consider your provincialization. There's a difference. You see the page number 50. Come to page number 50.
My lord, further direction.
You read from consequently. Consequently, the court therefore interferes. Court did not issue a direction to the respondent authorities to pass orders to cancel the provincialization. Court interfered with. And further issuing a direction to consider your case for provincialization. There was no direction to provincialize you in his place.
But my lord, meaning thereby, my lord, my case is there.
Meaning thereby that your case has to be considered. We only read the meaning which is available in the order.
But my lord, they have considered in 2020.
Whatever they may be.
Just
The last line. Consider the case of the petitioner for provincialization as a language teacher in Dokhin Pisandiai ME school. And the entire exercise was directed to be completed at the earliest, not later than 45 days from the date of the certified copy is served on the respondent number 2. Spera. the same not being carried out as directed within the period, same not being carried out within the period as directed by the coordinate bench, contempt petition was filed, which came to the contempt petition being contempt case number 431 of 2022. Stop this contempt petition came to be closed on 23/10/2025 when the respondents produced copy of the order dated 10th of March 2026, whereby the petitioner was provincialized. Petitioner's services were provincialized. Stop. Liberty, however, was granted by the court, by the contempt court, to agitate the order of provincialization, so it was spared. In terms of the liberty granted, the present writ petition has been filed with the petitioner, putting a challenge to the order dated 10/6/2026 to the extent that the provincialization order was not granted with effect from the date of the judgment dated so and so, rendered in WPC so and so, or at least with effect from the period, with effect from the expiry of the period of 45 days from the date of the judgment as directed. Stop. Is the submission of the learned counsel to the petitioner that pursuant to the judgment issued, the provincialization of the private respondent number 6 therein came to be cancelled by order dated 17 September 2022. Therefore, it is submitted that the provincialization of the writ petitioner ought to have been given effect to on the same date, which is 17 September 2022. Stop. Failure to do so has deprived the petitioner of the service benefits for no fault of him, as the court has, by the judgment and order dated so and so, passed in WPC so and so, had upheld the claims of the writ petitioner and directed regularization. So, then, MS so and so, learned counsel appearing for this education department submits that the petitioner's provincialization has been given effect from 10th of March 2026, namely on the date of the order, and there is no specific direction in the judgment and order dated so and so, passed in WPC so and so, that the provincialization must be given with retrospective effect. There are learned counsel to the parties have been heard. The although pleadings available before the court have been produced. The directions contained in the order dated so and so are also produced by the same judgment and order dated so and so. This court had allowed the writ petition with the following directions. There are 14 and 15. Extract. There are. A careful reading of the directions contained therein reflects that while the court interfered with the provincialization of the respondent 6 therein, there was no corresponding order passed by the court directing provincialization of the writ petition. Stop. Rather, direction was to the respondents to consider the case of the petitioner for provincialization as a language teacher in Dokhin Disandai ME School, and this direction was directed to be completed within a period not later than 45 days from the date of the certified copy of the order being served on the respondent number 2. So, reading the same directions of the court, it is apparent that the court did not order did not specifically order provincialization of the writ petitioner in place of respondent number 6 therein. So, direction was to the respondent to consider the case of the petitioner for provincialization. So, the submission of the counsel to the petitioner that pursuant to the order, the government had passed the order dated 17 September 2022, cancelling the provincialization of the respondent number 6. Therefore, the order having been complied in part, it was duty bound on the respondent authorities to comply with the subsequent direction of the court by provincializing the writ petitioner with effect from the same date, which is 17 September 2022. So,
No, my lord, 16 October 2025, my provincial. From 16 October 2025.
Yes,
where is that?
Page 56.
Whose provincialization?
Petitioner Abu Khair.
Uh,
They have cancelled provincialization 17 September 22 of respondent number 6. My provincialization was done with effect from 16 October 2025.
You are challenging this order?
Yes.
Right. Yes. However, the writ petitioner's provincialization was effective from 16 October 2025. Stop. Such submission of the writ petitioner does not have any force and cannot be accepted in as much as the direction of the court was to the respondents to consider the case of the writ petitioner for provincialization. Stop. The court, insofar as respondent 6 is concerned, the court did not issue any direction to the respondents to pass appropriate orders cancelling the provincialization of the respondent 6. Rather, the court had interfered with the provincialization by setting aside the same and directing the respondents, setting aside with the same. Stop. Therefore, the order dated 17 September 2022 passed by the respondent authorities really have no bearing, as on the same date, by virtue of the judgment and order dated so and so passed in WPC so and so, the provincialization order of the respondent 6 therein has already been set aside and interfered with by the court. The judgment and the order does not reveal that there was any direction by the court directing retrospective provincialization of the writ petition, including provincialization of the writ petitioner with effect from the date of the order cancelling the provincialization of respondent 6 by the respondents, state respondents, by the order dated 17 September 2022. Therefore, the claim of the petitioner that any direction is called for retrospective benefit of provincialization of the writ petitioner is not found acceptable. So, the writ petition, therefore, being devoid of merit and the prayers having been already considered by granting provincialization of the writ petitioner in terms of the direction of the court passed in order dated so and so, WPC so and so, writ petition stands dismissed. Interim order, if any, stands vacated.
Yeah, please. This is my lord, regarding non-payment of family pension, my lord, kindly see the last order. Order dated.
May I please your lordship? Can it be taken after some time, lordship? Mr. F. Con will appear in this matter, lordship, which on the left side another court.
Let it be on some other thing. Old lady, husband died. Friday, without any test.
Let us wait for him to come. Accountant General, your job starts only when the proposal is sent. Has it been sent?
No, ma'am. They say it has been sent, but my instruction is that it has not been sent because the petitioner is the second wife.
Petitioner is the second wife. Let him come. Let us see. After some time. Or you want it on Friday? Huh? Friday. This matter will be listed on Friday as per report. As counsel for elementary education, Mr. Fukan. Not present. Registered on Friday.
On Monday.
Monday.
Biplab. Please, Your Lordship. Since last 5 occasions, they are taking time for filing.
Lordship, I have received instruction this matter, Lordship, and as per my instruction, the Director of Secondary Education states that the petitioner does not satisfy the statutory educational qualification prescribed for provincialization under 2017 Act, Lordship. And also, it states that during the personal hearing held in the Chamber of Director of Secondary Education, the petitioner, in his written statement, admitted that he does not possess the requisite general graduate degree, which is a prescribed qualification, Lordship. As per
He is claiming what? Regularization,
provincialization. Lordship.
as a what? Arabic teacher.
Arabic teacher, Lordship.
He was provincialized, subsequently deprovincialized.
Lordship, as per rule, for the post of Arabic teacher,
Which rule?
as per Schedule 2 of the Assam Secondary Education Provincialized School Service Rules 2003, Lordship.
2003.
Lordship, the minimum educational qualification prescribed for the post of Arabic teacher is MM with at least 50% marks along with a graduate degree from a recognized university or Bachelor of Arts with Arabic as one of the subjects securing at least 50% marks together with a BT or BEd degree from a recognized university. In this matter, Lordship, the petitioner possesses an FM qualification but does not possess general graduate degree. Lordship.
2003 provincialization rules.
Lordship.
You are referring to the schedule.
Lordship. Schedule 2.
What does it say?
It says, for the post of Arabic teacher, MM with at least 50% marks along with a graduate degree from a recognized university or Bachelor of Arts with Arabic as one of the subjects securing at least 50% marks together with a BT or BEd degree from a recognized university. He doesn't fulfill the second requirement, Lordship. He does not possess a BT or BEd degree from a recognized university.
He is an MM.
Lordship.
He is an MM
Lordship.
with 50% marks.
He has FM, Lordship, FM qualification.
FM is higher or lower?
FM is, Lordship,
Higher.
higher, Lordship.
Lower, Lordship,
Lower.
lower.
FM is BA, Lordship. Lordship, may kindly see, I have furnished the document page 19, notification. FM is equivalent to BA.
FM.
FM is equivalent to BA, Lordship.
And
Page
MM?
19.
MM.
And this is page 19. I have annexed the document notification.
The requirement is MM,
Lordship.
not FM.
Not FM, Lordship. MM with at least 50% mark. Along with
Lordship,
BT,
let
BEd
them file affidavit, I will reply. to that.
Lordship.
Council for the elementary education,
Secondary, Lordship.
secondary education.
Lordship.
Submits that instructions have been received. I'd like to bring it on record by way of an affidavit. Prayer made is not disputed by the council. Released again after 4 weeks,
Lordship,
by which time the respondents will file their affidavit and the petitioner may also file the rejoinder affidavit.
Lordship, the date may be fixed because, Lordship, I have instruction that the school is going to attach with another school. If the school is attached with another school, he may lose service, Lordship. Others will be attached with that new school. As he is deprovincialized, he may lose, Lordship.
So you said let them file affidavit.
Lordship,
They'll file.
within a specific time, Lordship.
4
because
weeks. We've given
last-
4 weeks.
the date may be fixed. The last 5th occasion, they are taking time for filing a affidavit. Since last 5th, Lordship, you can see the previous orders, Lordship. Since last 5th occasion, Lordship.
19th August.
Lordship. Obliged. 35.
My pleasure. Lordship. Our institution name is Northeast Council of Health Science, Lordship, Medical and Paramedical Institution. our prayer for NOC also, we fulfill all requirements.
NOC for what?
NOC to run the institute also. Kindly see page number 35, Lordship, Annexure 8, Your Lordship. This is the letter issued by the Director of Medical Education Assam to the Commissioner regarding NOC, and wherein I fulfill all the criteria. Earlier two communication, page number 33 and 34, Your Lordship. Still, we are waiting for NOC also.
Yes.
Worship, in this case, we have communicated to the department. The department has also communicated to the appropriate authority. However, some time is required.
Which is the appropriate authority?
Lordship, in this case, it would be the chairman of the Assam Allied and Healthcare Council under the office of the Director of Medical Education. We have communicated to the Director of Medical Education as
When?
well. Lordship,
When?
we have communicated on last occasion on 14th of June, Lordship, when the matter had come up.
Why has it not been granted?
Several dates.
Either you reject
Yes,
or you
Lordship.
grant.
Yes, Lordship. We have communicated the same as well. Lordship, may give us a short period of time. We'll obtain our instructions accordingly.
In the meantime, Your Lordship, may pray for a direction to submit a fresh recommendation further.
Why do you want a fresh representation? If you want a fresh representation, we'll close it. We'll permit you to file.
Since 24 we are waiting.
But this case is filed in 2026.
What do you want? You want to file a fresh representation?
Yes.
Then we close it.
Yes.
Yes or no?
A direction may kindly given in.
What direction?
So the previous representation is still pending.
That's still pending.
That representation will finish. Then the new presentation will come.
Direction to what effect?
Waiting since 2024 for NOC as their letter CLC that we have fulfilled all requirements.
The writ petitioner before this court is agreed that the NOC file before the Assam, which authority?
Medical education industry.
Director of Medical Education.
Director of Medical.
Where is the representation?
Representation is page number
38.
30. Exactly.
Dated
14/12/2022
has not been rejected, has not been granted. NOC is for establishment of the Institute for Training of General Nursing Midwifery and Auxiliary Nursing cum Midwifery. Submitted that in spite of several communications, the NOC required to be issued to the petitioner has not been granted. So, Mr. M. Guya, learned counsel appearing for the health department, submits that further time be granted to obtain required instructions in the matter. The counsel for the petitioner on the other end submits that since the last 4 years, the matter is pending. He may be permitted to file a fresh representation before the DMA. Want to file?
Chief Director of Medical Education.
Director of Medical Education, seeking an NOC for establishment of the institution by enclosing all relevant documents. Stop. If such a representation is filed, then the appropriate authorities will consider the same and pass necessary orders thereon, either granting NOC or rejecting the claim within a period of 30 days from the date of receipt of such a representation. The above observation, without any finding on the merit of the case, the writ petition stands disposed of.
Much obliged.
Obliged.
The matter relates to non-release of area monthly salary. Proposal has already been submitted, page 105 manner by the Block Elementary Education Officer. And the same has been, my lord,
Non-release of? Non-release of?
my lord, area salary.
Area salary.
My lord. Proposal also will find page 105. There has been.
Where's elementary education?
Elementary.
Who's for elementary? Mr. R. Sharma, learned counsel for the petitioner, submits that the writ petitioners will go to this court praying for a direction for release of area salary. Stop. There are notice that the matter was issued on 22/5/26. Thereafter, when the matter is called, none represents the elementary education. MS Moore appears for. You're appearing for. Huh? Oh, you are for elementary. What is your instruction? Huh? Council for, I go to worry. Council for Elementary Education, Sport, submits that instructions are awaited. She prays for 4 weeks' time. Considering the prayer made, release this matter again after 4 weeks, by which time the instructions as sought for may be placed before the court and by way of an affidavit, if so advised by the respondents.
All right.
The issue is that non-payment of the B.Ed advance increment for B.Ed ballot by the state responding to the petition.
Advance increment.
Yes.
And some time is required to get the instruction.
Mr. B. Pulvester for the petitioner, U. Sharma for the secondary education. So Sharma prays for further time to complete the instructions. Release this matter again after 3 weeks.
A date will be given in that because.
No date. You make a mention after 3 weeks. Make a mention after 3, not listed.
That is the same manner, both the cases.
Similar order.
Both the cases will take together.
Let both these matters be listed.
That's an issue relating to downgrading the ACR from excellent to very good. And same leads to denial of the petitioner's promotion for the post of joint director. That downgrading was without any communication. And Lordship had issued notice on 23/6/2026. In fact, it is covered by the judgment passed by the division bench. But you will find the judgment at page 68. Same issue. Promotion was made to the junior officials.
Madam, here also instruction is not received yet, my lord.
The gradation list, Lordship will find page 25. Petitioner's position at serial number 7. Let them get complete instructions here. Mr. H.K. Sharma for the petitioner, Mr. U. Sharma for state respondents representing the Department of Higher Education.
Secondary education department.
Huh?
Secondary education.
Secondary education. Secondary.
No,
The
no.
higher is also a party.
Yes, yes. Higher is also part.
He prays for further time to complete his instructions, no matter. Prays for 3 weeks' time. Pre-made is allowed list after 3 weeks. Get me, please. They may fill up the again for 2 posts are again. 2 posts in what? The joint director. It is submitted that 2 posts are vacant at present in the cadre of joint director. Secondary education. Secondary education. How many petitioners? 1. 1. 1 post may not be filled up. There will be currency of the present petition. As it is submitted that the writ petitioner was wrongly downgraded, thereby denying his right for being considered for promotion. And as such, 1 post of the rank of joint director, secondary education may not be filled up without legal report. Released after 3 weeks. The Department of School Education, school education. Joint director, school education.
May I please your lordship? May I please your lordship kindly pass over the matter for timely. Senior counsel is on hold.
Who is the senior counsel?
Mr. Iyer.
Tell him it is a 2014 matter. He should give priority. Better we dismiss the matter. 2014 matter. Huh? You read the file. We'll take it up tomorrow. Tomorrow. No adjournments. Matter be called up tomorrow. Enabling the counsel for the petitioner. Apprise the court. Mr. S. Dr. Senior Counsel, assisted by Mr. G. Sharma. APS for respondent.
3 and 5.
3 and 5. Anyone for the education?
Yes, does.
Mr. S. Das appears for hiring. Tomorrow.
Lordship, instruction received in this regard, your lordship, selection process. Lordship, I would like to punish it.
Bring it by way of affidavit.
Lordship.
Why not file an affidavit?
Lordship, let them
Yes,
file
your
an
lordship.
affidavit.
Bring it.
I will also get a.
Yes, sir.
Whatever you want to say, bring it by way of an affidavit. The Mr. M. Bharu, is for the petitioner.
Instruction.
MSP Das appears for Department of School Education.
Secondary education.
Secondary education, submits their instructions that we received. Should like to bring instructions on report. Sharma appears for the 3 and 4. Let the affidavit be filed by the respondent within 2 weeks.
Yes, sir.
Matter be listed after 4 weeks, by which time the parties may complete their pleadings.
I'm deeply obliged.
Yes.
My lord, in this case, the petitioner before lordship is a linguistic minority institution established in the 1948. Now, my lord, we are agreeing with the continuous interference of the state in the management, control, and functioning of the administration of the school. We appointed the headmaster, the managing committee appointed the headmaster, but they are not giving approval. My lord, may I give a brief background of the facts of the case? So, my lord, the school was initially established in 1948. They were subsequently brought under the provisions of the Assam Secondary Education Provincialization Act 1977, India 1977. Immediately, my lord, thereafter we challenged the violations of Section 5 and Rule 4 of the Act before the Honorable Court. The Honorable High Court held that it's a minority institution, but in view of the management committee that is there in the Act, it is not ultra vires of the Constitution. Thereafter, my lord, we went to the Supreme Court. The Honorable Apex Court held that in the interim order, it gave a stay order on the order of the Honorable Court and directed the state to continue paying the salary of the teachers. Thereafter, my lord, finally in the 19
Yes.
Yes, my lords. (1995), my lords. The Honorable Supreme Court held that Section 5 and Rule 4 were indeed ultra vires of the Constitution, hit by Article 30, Subclause 1 of the Constitution of India. Thereafter, my lords, the process continue, and thereafter, my lords, in 2001, the Inspector of Schools wrote to the Joint Commissioner of Assam requesting as to how the appointments are to be made in respect of teachers and headmasters and how the salaries are to be paid. My lord, the Joint Commissioner Government of Assam on 22/2/2002 wrote that in view of the Supreme Court order, the appointments will be done by the managing committee and the salaries will be disbursed by the Inspector of Schools. Thereafter, my lords, the person who was appointed the headmaster in this case was also appointed as an assistant teacher way back in 2002, but his appointment was not being sanctioned by the government. So he again came to this court, and this court, my lord, in 2002 gave a direction to the Inspector of Schools to satisfy as to whether the appointment was made against the vacant post, and thereafter to give him the regular appointment. Subsequently, he was given the regular appointment. Now, my lord, the dispute started from 2014. The management committee appoints headmaster. The state does not approve the same. The latest dispute, my lord, is the impugned order. My lord, will find at page 180.
The order of 21.
Yes, my lord, 2021. So, my lord, I'll take your lordship to what has happened. So, my lord, in 2021, we appoint Ram Nirav Singh as the headmaster in charge. The government doesn't listen to us and instead orders Anand Kumar Shah to be the headmaster in charge. Thereafter, my lords, we went through a regular recruitment process. We advertised in newspaper. We conducted interviews, and thereafter again we selected Ram Nirav Singh to be the headmaster.
Pleadings are exchanged.
My lord. Yes, my lord. Yes, my lord. Yes, my lord.
Right.
Yes, madam. You have not filed our affidavit. My lord, they have filed the affidavit. Secondary education. Yes. Affidavits have been filed.
School education. School education.
Secondary education, my lord.
Department of School Education.
Yes, my lord. Respondent number 1. So, my lord, basically, we are recommended the headmaster. They are not approving it. Now, they are of the view that 1977 Act was repealed in the year 2018. And secondly, my lord, because since they are giving us financial aid in the way of paying, that's why the control will be with them. My lord, now my case is that 1995 Supreme Court order still stands. And there have been a number of constitutional judgment cases by the Honorable Apex Court wherein it was said that.
This will require hearing, proper hearing.
My lord.
Who are the other respondents here?
In item number 43, Your Lordship, I am appearing for respondent number 5, Your Lordship, the school managing committee.
This is item number what?
This is item 42 and 43.
42. Who is appearing in 42? 42, there is no school management.
My lord, we are the petitioners.
You are the petitioner. Oh,
Yes,
you are the petitioner.
Yes.
Who's for respondent 5?
My lord, for respondent 5. And he's for respondent. No one has appeared for respondent 5 in item number 40.
Service complete.
Yes, my lord.
Issue rule, this matter will require
My lord,
hearing.
may I make a just very small submission? This person, my lord, Sri Anand Kumar Shah, who was appointed as the headmaster in charge, in 2026 of March, he has been transferred as headmaster to another school. So now this school is operating virtually without a headmaster and a joint of disbursing officer. So, my lord, there is a difficulty with regards to the administration of the school. My lord.
No, who gives the order for in charge headmaster?
My lord, we had elected Ram Niroj Singh, the current the petitioner in item number 43. He was never given the approval by the state. Instead, the state had elected Anand Kumar Shah to be the headmaster.
Therefore, the
in charge.
matter will have to be heard.
Yes,
on
my lord, the practical difficulty now is happening is that although this Anand
When
Kumar,
was he transferred?
my lord, in March 2026.
You have to hear the matter.
So, my lord, in the interim, my lord, if Ram Niroj Singh can be given the headmaster in charge.
We don't know what is there, who's to give the order, what is the difficulty in not giving the order.
I understand.
You have to satisfy. Your claim is that you are a minority institution. You are free to do anything you want.
No, my lord,
in terms
not
of
anything.
appointment.
My lord, the right is not an unfettered right.
No. In terms of management, you have
Yes, my lord, with regards to appointment of teachers.
appointment of teachers, etc.
Yes.
And according to the government, since you are grants in aid,
Yes, my lord.
you are enjoying the grants in aid, they will have control.
Yes, my lord. That is what the government is claiming. But my lord, this Honorable Supreme Court had made it clear that
Which judgment?
My lord, there are two judgments. One is this judgment itself.
There are subsequently several judgments.
Yes, my lord, there is.
So what is the law today?
So, my lord, the law is, I'll just rely on one judgment. Secretary Malankar. So, my lord, this judgment had interpreted the TMPI judgment, which was the 11th bench judgment. My lord will find the issue.
No, subsequent to this, there are other judgments.
Yes, my lords. Everything was categorized, but my lord, this judgment had clarified the role, and this subsequent judgments have also stuck to the stance taken in this judgment, my lord. Because my lord, TMPI is a 11th bench judgment, and TMPI has been properly interpreted in this judgment with respect to minority aided institutions. May I take your lordship to the issue, my lords, the ratio?
We are not hearing the matter today. Matter be listed for hearing on 6th of August.
Very well.
Both the matters. Yes. Yes.
Madam, let's find out non-payment of family pension and area subsistence allowance.
Lordship, as per the last order, there were two queries raised, Your Lordship. One was regard to the payment of the area salary, Your Lordship. The second was with regard to the pension of the petitioner. Now, with regard to the petitioner, Your Lordship, I have placed an instruction where it is stated that the final family pension has been sanctioned by the Directorate of Assam, Director of Pension Assam, House Paid, by PPO dated PPO number so and so dated 22/6/2026, Your Lordship. And with regard to the area salary, Your Lordship, considering, Your Lordship, that the current budget session is going on and the finance is also not an interested subject to BDC, we are praying for some time for finalization of that aspect, Your Lordship. Otherwise, Your Lordship, other amounts have been sanctioned, Your Lordship.
I have received only leave encashment amount.
What are you trying to convey by this?
Lordship, what I am trying to convey is that, Lordship, the only part remaining on the part of BDC is the payment of the area salary, Lordship. The others have been sanctioned respectfully by us, Your Lordship.
So sanction is one thing,
Lordship,
payment is another thing.
Absolutely, Lordship. I understand, Your
So
Lordship.
they are asking for payment, not for sanction.
Lordship.
So who is to release the bills?
Lordship, with regard to With regard to the GIS insurance, savings, leave salary,
You
DCR.
have sanctioned.
Lordship, yes.
Now, when is the payment
That is the
going to
issue, Your
be?
Lordship. Due to the ongoing budget session, Your Lordship, there are some difficulties, Your Lordship.
What difficulties are there?
Lordship, in view of the fact that it has been.
You can't sanction an amount unless
The budget is there.
budget proposal is there.
Absolutely, Lordship.
Then, so if you have sanctioned this amount, the provision is already there.
Lordship.
Now the question is why the amount has not been released.
Lordship, as per my instruction, Your Lordship, the matter is pending at the secretariat level of the BDC, Your Lordship.
So please get instructions,
Lordship.
complete instructions,
Lordship.
why this amount has not been released.
Lordship.
When can you get it? Mere submission that budget is going on
understand, Your
is not a ground
I
to
understand,
release,
I understand.
not to release.
Lordship, it be after 10 days, Your Lordship.
Standing Council BTC submits that by placing a communication dated, what is the date?
14 July
14 July 2026. That the following amounts, people GIS insurance, GIS savings, so and so has been sanctioned. And also the final family pension has been sanctioned by so and so, dated so and so. And area bill amount of rupees 45 lakhs 44. This is for whom? For the person concerned.
Lordship.
45
Lordship.
lakhs is to be paid.
Lordship.
With effect from so and so is to be paid by the DDU. So the learned standing council, however, is unable to apprise the court as to why the amounts have not been released if they are already sanctioned. Stop the praise for 2 weeks for the time to complete the instructions. Prayer made is allowed, released again after 2 weeks on a date to be fixed by the registry. And as so and so appears for the writ petition. P count.
P Talukdar.
P Talukdar appears for the writ petition.
It is regarding payment of area salaries, madam. The petitioner LP school teacher, madam. So that they filed the affidavit in opposition. Only to be taken that there was some misappropriation of school building fund. That is why their area salary is not. Now, my humble submission with your lordship, if there is misappropriation of fund, that may be taken into by the government in their own way. And now they plead that there is misappropriation of fund, and that is why area salary is not.
Misappropriation.
Misappropriation of fund of school building money. So, my lord, here it will be the case that if there is misappropriation, there will be departmental proceeding and show cause will be issued to me. And they said that the show cause has been.
Who is for
issued
the
on-
respondent? Yes, what is your?
Lordship, show cause has been issued and thereafter the
Show cause on whom?
show cause notice to the petitioner.
He had misappropriated.
Yes, Lordship.
Then
Thereafter, he was asked to submit the written statement within 15 days, Lordship.
what happened after that?
Thereafter, he did not submit any written statement.
I already filed my show cause report.
What is the status of the inquiry?
Lordship is still going on, Lordship. Departmental proceeding is still going on, Lordship. Inquiry of.
So let the inquiry be completed. After that, if you are exonerated, the claim for area salary will be looked into. Now, assuming there is an allegation against you that you have misappropriated some funds. On top of that, you are asking for area salary. So the
No,
department.
that is their subsequent inquiry. I filed the writ petition in 2025. In 26, they want to say that some misappropriation was there. And your lordship would be pleased to see the area salary started from 2024.
But now there is a
My lord.
departmental proceeding against
My lord, my lord,
with these allegations.
my lord.
Now,
My lord, my humble submission before your lordship.
We don't find
My
the
lord, it will-
quantification
it will
of the
not
amount
be- it will not be
misappropriated.
proper. My lord, it
What
will
is the
not-
amount misappropriated?
My lord,
Amount that was not
Huh?
amount.
Then how do you know how much he is misappropriated? What is misappropriated?
Lordship, our affidavit paragraph 4, we have written suspension order 19/6/2025 in annexure 1. Annexure 1.
Annexure 1.
Lordship.
Annexure 1 is a suspension order.
suspension.
Thereafter, Lordship, statement of allegation, annexure 2, page 41. Statement of allegation is in page 42. Lordship.
No, we have seen that, but that does not quantify the amount misappropriated.
Lordship, now the inquiry is going on, Lordship.
The inquiry, firstly, you have to determine what is the amount misappropriated.
Lordship, I'll bring the instruction.
Yes. Further time is sought for by the Standing Council, Karbi Anglong Autonomous Council, as to the status of the departmental proceedings initiated against the petitioner.
My lord, and to disclose what amount has been misappropriated.
That will disclose it in the inquiry. It is for our consumption that we inquired. You have, if you want, you go and file a reply.
My lord, my humble submission before your lordship, my area salary is amounting to 26 lakhs. Supposing, my lord, against a building, some 10 lakhs or like this, that has been sanctioned. I will reply to that whether misappropriation will be proved or not. They have to say before your lordship that this is the amount suspected to be misappropriated by the petitioner.
Therefore, we want to find out.
In that case, other amount is to be paid to us.
Therefore, we want to find out what is the status of the inquiry.
My lord.
What has happened to the inquiry?
And also, my lord, they may produce before your lordship that what amount has been misappropriated.
No, we'll not ask them for that. You go and ask for the amount which is being misappropriated. You have been issued a show cause notice. You are entitled to go and verify the documents. Have you done it?
My lord.
Have you done the verification of the
No,
document?
Lord, in that document, nothing is there.
Have you, what reply have you taken?
My lord.
Where is your reply?
My lord, I have filed my reply.
Where is it?
Yes, my lord. It is on record.
Play page. Let us see. Reply.
It is from 43 onwards, my lord.
43.
It is 43. 44.
Dear Lordship, they have said that they have sought for further time to file the written statement in their reply.
Well, in the meantime, we have filed this reply.
Where is the reply? Copy of the reply.
In that case, we have to file another reply. Next thing.
We are not giving you legal advice what you should do. We list after 4 weeks, enabling the Standing Council to complete their instructions as to the status of the departmental proceedings.
My lord, I am a LP school teacher, my lord, they are not giving this amount from 2000. Now
You are the petitioner before the court. You must know what documents should be available before the court in support of your contentions. You are making a claim for arrear salary. They are raising a counter claim that you have misappropriated some money. Some inquiry is going on. You have filed a reply. The reply is not before the court.
my lord, I am annexed. Apply.
We are not suggesting you annex. We are just thinking aloud. It is your decision to decide whether you want to annex, not annex. Mr. Arboro appears for respondent number 6. Mr. A. Fugan appears for respondent 1 and 2.
Make me your this matter relating to conversion of the petitioner's child care leave to earned leave. Petitioner is a
assistant professor in English department of Nagaon Girls College, my lord. Her minor children, boy, was treated in Kolkata. Her husband was treated in, my lord, Kolkata in R.N. Tagore Hospital because of kidney transplantation. And her own mother was also treated in at the same time in, my lord, GNRC hospital. During that period, my lord, chief petitioner submitted one application before the principal to treat this period as child care leave. But ultimately, at the time of joining, my lord, she has found that all over her application, it is this period, my lord, circle period marked as EL, earned leave. This is the case, my lord. The petitioner will not serve the copy and they have appeared, my lord, that now till now it's a long time, my lord. They have not filed any affidavit. That's a, my lord, it's misunderstanding.
Who is the authority to grant you the leave?
This principal, my lord.
Principal.
Yes.
You have not enrolled, you have arrayed the principal.
Yes,
Who's for the principal?
I am appearing for the college, phone number 3 and 4, my lord.
Yes.
So what happened, my lord? The petitioner has a habit of availing childcare leave every time, my lord. Till date, he has availed the leave of many times, my lord. And if I may take your lordship to page number 39, page 40, my lord. The circular under which she is claiming the childcare leave, my lord. Lordship got it?
Yes.
Page 40, column 12, Roman 12.
Yes.
May I read it? The childcare leave shall not be demanded as a matter of right, and under no circumstances can any employee proceed on childcare leave without the prior sanction of the leave by the competent authority. Well, here in the instant case, what happened, my lord? The petitioner had submitted an application to the governing body principal, and without awaiting for the approval of the same, she proceeded on childcare leave. This is a clear violation of this procedure, and she cannot claim it as a matter of right. It is the discretion of the entirely governing body has the discretion to either grant or reject the childcare leave, my lord.
No, but how will you exercise your discretion?
My lord,
the purpose of the leave is to care for a minor child.
Yes, my lord.
Of the person concerned or of the female lady employee.
My lord.
You as a governing body who is not a member of the family, how will you exercise your discretion
Lord,
whether this child care is to be granted or not granted on the face of it?
There is a proper form, my lord, she has to submit, she has to give the supporting documents, my lord.
But you said she filed
She
it.
has no, she had filed it, but she did not wait for the approval. Without the approval, she left for out of the workplace, my lord.
If the situation demands that urgent care is to be taken, then some cases, when was the leave? When was the application filed? When was it filed?
My lord, it was some 3 days before that, my lord.
Then how much time do you want to get an approval?
We had a meeting on 7th, my lord.
No, you may have a meeting on any date, but when a person applies for a child care leave, 3 days before, there has to be some
Well, there's a long
consideration.
history of this petitioner, but I'll file an affidavit, detailed affidavit, giving entire facts, my lord. Lord, you may give me 2 weeks time, my lord.
In between the petitioner
My lord, she has not been denied and leave, my lord. She has heard CCL has been converted to unleave. She has not been declared unauthorized absent, my lord.
She total child care leave she is entitled. She took earlier one. I have stated.
And she did not submit any documents. The documents are submitted at a later date, my lord. If the son is ill, my lord, along with that application, she had to submit the documents. She did not submit, my lord. Only when the principal informed her that your child care leave has been converted to earned leave, then she sent her some documents, my lord.
What happened, my lord? In such a situation, when the husband was treated, only she is the person, my lord, to take care of her husband, her own mother and the child at the same time, my lord. Is it possible for her to? She has submitted the application, but definitely, if she has not submitted, but subsequently she has submitted these documents also, my lord. But this is only because some misunderstanding between the petitioner and the principal. So, my lord, it can be, my lord, converted easily to child care leave. There is no such hard and fast rule, it's a notification only. And with due respect, my lord, I have submitted this application, but at that time, this petitioner failed to submit, could not submit this because treatment was in Kolkata. Therefore, my lord, if there is any, well, could have, my lord, considered this. And otherwise, my lord, there are so
So is it a
provisions.
case that the grounds on which the leave has been sought for is disputed?
My lord,
Disputed.
there are some disputes.
You are
Because-
denying the claim that she was on childcare leave for a child.
My lord. In
Then
fact,
do an affidavit.
we'll file an affidavit.
You should have filed an affidavit. 25 matter. Yes, please file it within 2 weeks.
My lord.
That may kindly be fixed. my lord.
Mr. R. Goswami appears for the petitioner. Mr. N. Barua appears for the
3 and 4.
respondents 3 and 4. Mr. S. Das for respondent number 1 and 2. The respondents are permitted to file their affidavits within 2 weeks from the date. Petitioner may also file rejoinder affidavit if so advised. The affidavit in opposition that may be filed by the respondent, yet release this matter again after 4 weeks.
Okay.
You want a date?
Yes.
18th
August.
August.
Oh, obliged.
Sir, in this case, the instruction is awaited, but another 2 weeks time will be granted. Otherwise, we have rejected her claim, but against that, he has opposed before the honorable court.
Finally, paying the order with the 10/6/26.
Yes, sir. Time was thoughtful on that day, but
On that day, also, so far time.
You are to file the affidavit on or before.
Yes, yes.
yes, Lordship, but
Then-
this is the third round of litigation. We are considering.
Whatever it may be, there is an order of
Yes,
the
Lordship.
court.
This time, Lordship, it will be invariably be filed, Lordship.
No, but it is not filed. So what is to be done?
Lordship, another time may be
We'll,
granted.
we'll give you time, but we'll impose cost.
Lordship, one last chance may be granted, Lordship. I will personally take responsibility to file this.
So what guarantee is there? There is a specific order that you shall file your affidavit
Lordship, I
on or
apologize,
before the next date of listing.
I apologize, Lordship, but this time, Lordship, it will not happen. It will be invariably be filed, Lordship.
Yes.
My personal guarantee, Lordship.
MS
And so on.
M. Sharma, Learned Counsel, Mr. PP. Dotto appears for the APSC.
Lordship, we standing counsel, secondary education.
Huh?
Secondary.
Secondary education, standing counsel. Submits that in spite of efforts to file the affidavit, he could not file it because of personal difficulties. He therefore renews his prayer for further time. Stop. Considering the submissions made, if further time is granted, for the ends of justice, further time is granted to the respondents to file their affidavit within 2 weeks, failing which the court will proceed to pass orders on the basis of the pleadings available on record. Release this matter again on 7th of August.
Lordship. Okay.
But Lodima court ordered it 13/7. Service upon respond number 7 is complete. So all the respondents are served. However, no affidavit has been filed yet.
Pursuant to issue of notice, service on all respondents have been complete as per Lozima court order dated 13/7/2026. Stop. Respondent's number, your Mr.
H. Das.
H. Das appears for respondent number 7. And Who's for secondary education? Mr. P.P. Dotto appears for respondent numbers 1 and 2 and 6.
Two, I think finance.
Huh?
Two is finance.
Finance. Mr. H. Alia appears for respondent number 2. And any government advocate? There any government advocate? Who's appearing for number 5?
Director of pension.
Huh?
4 and 5 would be director of pension.
Who was here? Government advocate? S1 appears for respondent 4 and 5. The respondents are granted 3 weeks further time to complete their instructions and file necessary evidence. This matter again after 3 weeks.
May put a date. The August.
10th of August.
Much of
Sorry. 14th August.
much of. In this case, I have received the instruction. I need to file an affidavit. I have received the instruction.
My lord, similar matter had already been disposed of. My learned friend agrees. But my lord, in that case,
Then affidavit,
my lord, they can file.
Which order?
My lord, the order is at the last page, starts at page number 51. It pertains to Morigaon district, but the present present petition belongs to Nagaon.
You examine and come back on Friday. Why unnecessarily divert the matter if it is covered?
Entitled as per the decision of the division bench.
Hmm?
His entitlement has been rejected due to the order of the division bench.
Which division bench order?
So we have annexed here also.
Is rejected.
No, my lord, what has happened? My lord, those graduate teachers, my lord, who are receiving the grade pay of rupees 6,800.
We are on this issue. Mr. Dotto, you want to say that the order at 51 does not cover the case?
Let me examine the thing.
Okay.
I'll have to examine and I'll affidavit.
If you examine, we'll fix it on Friday. If you file affidavit, we'll give you further time.
Let it be Friday.
Friday?
Friday.
All right, is agreed to. It's on Friday. Sorry, Monday. It will be on Monday. Enabling the standing council secondary education to apprise the court whether the matter is matter stands covered by order dated 23/5/2025 passed in WPC numbers 2676 of 2025. Monday. Mr. A.R. Bhuiya, second counsel, assisted by Mr. N.J. Chaudhary. Just for the petition. Obliged.
Maybe pleased to have my lord earlier order, my lord, seen.
Lordship, here in this case, Lordship, is an issue relating to the non-payment of area salary petition of October 22 to February 22. Now, Lordship, department has seeking instruction from the jurisdictional inspector of school whether the petitioner were working during those period or not, Lordship. That I need 2 week time, Lordship.
Last order says no further adjournment.
Yes, Lordship. But today, Lordship, I have been telephonically informed from a department that verification process is going on. Upon completion of the verification process, other proposal has already mooted.
This order was passed in your presence.
Yes, Lordship.
And my lord, Lordship, page 79 is clear, my lord. The director already issued communication to the government level for payment of this period, my lord. Page 79 and it's a file.
Yes, Lordship. From the director, it was sent to the government, and government has sought for clarification from the directorate. Accordingly, the directorate has instructed Lordship, asked the jurisdictional inspector. The petition has been clubbed, Lordship, for 5 to 6 districts, Lordship. That's why caused some delay, Lordship, getting the instruction.
Mr. The order here is very specific.
That's it.
Mr. M. Borbuya, Learned Counsel, appeals for the petitioner, Mr. Dr. Standing Counsel, Department of School. Mr. Doctor renews his prayer for further time that the instructions sought for are required to be made available to him by the jurisdictional office of the jurisdictional inspector.
Inspector of School.
Inspector of Schools, and they're still awaited. There are Mr. Via on the other end refers to the last order dated 8/6/26, whereby further time was granted to the Standing Council, School Education, and they were directed to file their affidavit, invariably file their affidavit on or before 25/6/2026, and no further adjournment shall be granted to the respondents to file their affidavit. So, a further direction is issued that in the event the affidavit is not brought on record explaining the reasons as to why the salaries of the petitioners have not been released, the court would be constrained to considering the lapse of time occasioning the matter to pass orders requiring payment of salaries, would consider issuing orders directing salaries of the petitioners with imposition of interest to be recovered from the officials who are responsible for the delay occasioning the matter. In spite of such specific orders, the respondents have not filed their affidavit and further time is granted, sought for. Since the affidavit has not been filed as directed and further time is sought for, the petitioners are permitted 2 weeks further time to file their affidavit. The respondents, subject to, however, payment of cost of rupees 2,000 to be recovered from the hearing officers and deposited before the Gauhati High Court Legal Services Authority. Release this matter again after 2 weeks on 31st, on 3rd of